Well, that's pretty good. All right, I think I'm almost fully logged in now. All right, well, good morning, everyone. We have a trial calendar, a 1-week trial calendar that begins next Monday. I think in my courtroom, I think we'll be ready for 8D. We got a tour. I mean, it's just one room, but they showed us how the lights work, et cetera. So we should be back in 8D. Today, I will work through the calendar to see which cases remain, and then I will contact the lawyers of the remaining cases to have a lineup for Monday, so we know who ought to be here expecting to go to trial. But maybe we'll have some pleas today or other announcements. We'll see. Positions 1, 2, and 3 have already resolved, which gets us to position 4, Mr. McGriff. Is Mr. McGriff here? I think his lawyer's here.
Mr. McGriff, are you here? He knows to be here. I texted him. I assume he's en route.
Okay.
I hope he's en route. He said he would be here this morning. I did speak with him earlier, so I expect him to walk in any second.
So he responded to your text saying,
Yeah. I've been
okay.
communicating. He knows to be here.
He's always been here before.
He's
Okay.
He should maybe traffic. I don't know. He lives in Lithonia, so I don't know if little traffic or whatever. But he will be here.
Okay.
He better be here.
Ms. Clark?
The state, we'll wait until the defendant.
Good. All right, we'll give him some time. We'll get through the rest of the calendar. It's a first rainy day in 2 months. People are probably working through those issues.
Want me to wait for my announcement until he gets here?
Yeah. He should be here so we can talk through it.
Step out, call him, and just make sure there's no
Okay.
surprises here yet.
All right. Matthew Chalmers, Mr. Partridge sent an email and he's in municipal court, but will be coming here directly from there, expects to be here 9:30-ish. Is Mr. Chalmers up?
Yes.
Okay. All right. So let's wait to hear. Mr. Rao, you will be the Chalmers person for today?
Yes.
Okay, great. Corey Suttles.
He's my judge. I spoke with him yesterday. I do expect him to be here, but I just realized I didn't tell him about the courtroom switch, so I
Okay. I guess there could be people up on the 8th floor. All right. Any change in what's happening with Mr. Suttles?
Should be a plea, judge.
Okay, to 3 cases?
Yes.
All right. And Ms. Nix, you're handling all 3? Okay. Position 8 and 9 pled. Michael Reynolds, he's in custody.
He's my judge. I need to speak with him. We are ready for trial, but I'll speak to him once more.
Okay, and Ms. Nix, are you handling that for today or forever, because that unit only handles like arraignment and not?
Miss Rutland is here.
Oh, she's here. Hey, how are you?
Doing well.
I was saying only good things about the unit. Just Ms. Nix said, like, I don't know that they're gonna handle the trial. Like, well, what will they handle?
So we're gonna tag team that.
Great.
I did learn that the officer actually, or the investigator is not gonna be available until Thursday. So I hope that if this was the one that goes next week, if we could wait to pick the jury until Tuesday.
Okay, if we did that, would we finish next week? Because not finishing next week would get complicated.
We should.
Okay.
I have, I think, 4 witnesses. So we should finish next week, but
Okay.
after my last trial was expected to go 2 days and it went an entire week, I'm hesitant to give any kind of promises.
All right, well, we'll drill deeper into what all that means, if this is the one that's going out. So Mr. Reynolds is here, he's in custody, you're gonna talk with him and we'll see what's happening. All right, 11 was continued, 12 is a plea. Mr. Previllon is here, good morning, sir. My understanding is that this case is ready to go and we would not have to start Tuesday. We could start Monday.
That's correct, thanks, right.
The fence is ready.
Okay, and there are like 800 motions that got filed and we'll work through that. But I mean, there's the standard pretrial stuff. Okay. Mr. Did I pronounce your name correctly? Is it hard? How do you say your last name? Pavilion. Sir, your case is on the short list for trial next week. So you should stay in touch with Ms. Rios. You should expect that you'll need to report on Monday. Probably not to this courtroom, the one you've been to before. And be ready to go forward. Your lawyer's ready and the prosecutor's ready. So I'm not going to keep you here anymore today. Ms. Rios may want to talk to you. If she says it's okay to go, you're free to leave. Just know that I will likely see you on Monday. It may be that you're number 2, but you'll still need to show up on Monday in case number 1 is a plea Monday morning. But I'd be surprised if you are not coming back on Monday. Okay? Mr. Romero. So Ms. Cabrera was excused. I don't know what she relayed to Mr. Romero. I know what we're working through. I don't know if you're concerned that Mr. Romero is not here and he may be stuck in the same rain-based traffic as everyone else.
I am slightly concerned he's not here since the case is still open. It is our intention to not cross the case.
Okay.
But
So Ms. Cabrera is around. I mean, she's not, I think she went to Cobb, but you could reach out to her to have her reach out to her client to have him show up.
yes, we've been texting.
Okay.
I'll see.
All right. 15 resolved, 16 had to move, 17 had to move, 18 resolved. Michael Stevens. Good morning, sir.
That should be a plea this morning. I just have to talk to my client a little bit and the state, and then we should be solving today.
Okay. Mr. Stevens, Ms. Rios is going to talk to you. It sounds like this is getting sorted out today. That's your decision, of course, not mine. But it may be we do that this morning. If not, we can go to trial on Monday. Okay. Mr. Gomez, did he get brought over?
Yes.
Okay. I can talk to him at the door if he's up, but his lawyer won't be here. She's, I can talk to him if you think that would be helpful.
No,
Okay.
just take it down.
Okay. Why don't we do that? Jerron Reynolds. All right. We were not expecting him. Is there a bench warrant in place, Ms. Nix? Do you know yet? Or okay.
I know that one was mixed earlier, but
I don't know one way or the other. I know that was thinking maybe he'll show up. Who knows? Not so much after he got his ankle monitor taken off. We will look. Okay. Duranta Jones, same situation. How about Eric Musa? He's in custody. Ms. Rios?
Yes, Your Honor, I would like for us to reset this case. Me and the state have essentially been talking, and we do have a different offer that we were willing to accept. He has an open case that we want to wrap into that, and it's about to be indicted.
What case number is that?
Let me see, I have a CP.
yes, sir. When I was sending a revamped offer yesterday, I was looking at his jump at it and he also has another case pending. And
It's
that
23 CP 219143.
Okay. And what's the main charge in that?
It's
aggravated assault.
Another aggravated assault. Okay.
from the same plea. It
Oh,
looks like it should have been all divided together. I'm not sure why it was separated.
different alleged victim?
Different victim, different location. It was a,
Was he having a bad day or?
I
Done.
know very little about this other case.
Okay.
I learned about it yesterday. There is a draft indictment that was created day before yesterday, actually, and so it should be indicted maybe today, maybe by the end of the week. But I think the defendant was interested in the offer that I made on the other case. It's just I did not know about this other one until just today.
As you learn more about this unindicted case, is that going to change your offer? And I mean, should he not take the offer on this case, or how?
As we were discussing, I think it will all be a misdemeanor situation.
Well,
Not so
I
fast.
made an offer to the case that is on the calendar. I I reached out to the victim in the other case yesterday to attempt to make a global offer, was not able to get her. But I can't say right now if on the other case it would be a misdemeanor.
Okay. I guess he could plead to the indicted case and get a misdemeanor today. It may be that if he waits for the other case to get charged, then it gets more complicated, I guess. I would,
it seems like when I was talking to Vic, that she'll be okay with holding that offer open. And so I would rather, in the hopes that if she talks to the victim is okay with doing the misdemeanor on that case, we wrap it all together versus, so in his situation, just some details, he is on a asylum because he cannot go back to his home country.
which is where?
I believe Sierra Leone. Might have that wrong, but it's West, I think it's that country. And his dad was in the government and he will be killed if he fit back. And so
That's a bad outcome.
yeah, so
Okay.
we're trying to make it that immigration is less likely to send him back.
Okay.
And the reason for the misdemeanor offer is because after months of requesting, I finally.
This is the one where we're looking for the video inside the store. Hey,
I
Mr.
received a screenshot of the video, but not the video.
Okay.
The officer is continuing to look, and if our case suddenly gets better, this misdemeanor offer might go away.
Okay.
At this point, the defendant has 18 months of jail credit.
Oh.
And an offer.
Okay. And the other case can't be particular. It's a 23 CP, so it's not particularly new. Okay. Do you have a perspective on what we ought to do, Ms. Nix? I don't mind resetting it, but if he is sitting in jail, he is. I want to minimize that delay. But it's at his request, not because the state's saying not ready. You're ready to go forward with the plea in one, but I understand why he wants to try to wrap it all up. Does it seem like the charging team is going to indict this even though no one's talked with the victim?
I don't know that no one's talking to her.
Okay, you just weren't able to reach her yesterday in the 10 minutes you had to try to track her down.
Yes, at about 5:20.
Okay.
I tried and I left a voicemail. So I might get a voicemail back from her today. I don't know, but I expect that this will be indicted in the next few days, just because it has adopted it as a been prepped for indictment.
Okay. So,
Be fine with the.
all right, should we just bump it to the December trial calendar and have it be an add-on? I mean, that calendar's already been published, but we could do an add-on to that.
Yeah, yes, Your Honor, and if we get that information before, we could bring it up sooner.
Oh, yeah, no, there's no need, but well, I want a backstop that I know Mr. Musa is coming back just because people get distracted by all the other cases they have.
Yeah.
So we'll move this position 24 to the December calendar as an add-on. It may be well before then, the new case gets indicted, it would get green sheeted here. And if Ms. Nix develops a perspective such that you want to work it out, let's do that. We'll slide it into something else. Okay. Do you want me to tell that to Mr. Musa or you'll tell him?
I will go back.
Okay. Javon Jordan,
Oh,
does he have, the other two I've confirmed, they have bench warrants. Let's see if his is in the system also.
I don't think he bounced up here. I think at the last calendar, we knew if he was in.
Oh, you were saying you didn't think he should, I have bench warrant written on here. Were you
No.
forecasting he wasn't gonna show up?
I think I said I haven't had contact with him, and so I wasn't sure if he was going to appear, because he was released from the cap jail.
Got it. Okay. All right.
I think our expectation was that he wasn't gonna show up.
Got it. Well, is there a Mr. Jordan here? Oh, all right. Well, we'll see if he slides in with everyone else, but that may be the outcome there. And we already dealt with Mr. Simmons. So one more time. Did Mr. McGriff make it?
Yes, sir, Judge. Mr. McGriff just walked in with his
Great.
brother.
There he is.
Apologize for that he is a little tardy, but I guess it was the rain.
No worries. Good morning, Mr. McGriff. The state has announced ready, Mr. Schnipper, in this case, your announcement.
I met with Ms. Clark yesterday at Investigator Rucker. Went over a lot of things, a couple things, and let me just, it's become, number one, there were some key pieces of evidence that Ms. Clark thought that was forwarded over to me, but wasn't. And I got it last night. They were recordings of the lead detective and the defendant, two of them. Obviously, that's material. Number two, based on 1716(8)(a), the state is to get the witness list to defense within 10 days. The initial witness list was to me with only two witnesses on April 13, 2023. Then I had forwarded mine yesterday, which is under the statute, at least 5 days before trial. Ms. Clark did amend hers and added 29 additional witnesses. So and that's not within the 10 days of trial. And also furthermore, and I did for this, the court last week, as you know, I don't know if you remember, I had not to get too graphic.
No. I remember you had some serious medical work done.
It's still ongoing.
Okay.
I have to go back on Tuesday. I have a doctor's note per se that I forwarded the court. I can bring to you at noon. There has to be more work done with my gums, my bone. I don't, talking's painful. So, but what I would ask respectfully, if this could be specially set to adhere to the statutory guidelines to maybe the next trial calendar, maybe have it first off in pending negotiations. I don't know if we're going to be able to work this out. I'm hoping we can. I did forward over some new evidence that we just got recently to Ms. Clark. She has it. And I know that she I don't want to speak for her, but is going to look into it, and I'll let her make her announcement. But I'm hoping we can get this resolved prior to trial, but I don't know if we can.
Okay. Ms. Clark, do you agree with the timeline Mr. Schnipper provided about the witness list part?
Yes, Your Honor, I did file an amended witness list on yesterday,
Okay.
but the,
It's entitled amended, but it's basically, it sounds like for the first time, here's the whole, I mean, the indictment always lists like 2 or 3 names. But what you filed on the 13th yesterday would be, hey, this is likely the folks we're going to call at trial.
correct.
Okay, is it the first time that was provided to Mr. Schnipper?
Yes, Your Honor.
Okay.
Also, Your Honor, yesterday, in the meeting, Mr. Snipper provided some reciprocal discovery to me. And so it will require the state to look into that. So I would need time to look into that as well.
Okay, just generically describe what this reciprocal discovery is.
A recording from a possible witness, also a psychosexual evaluation of the defendant, copies of text messages from, I guess between the defendant and the victim in this case. So I would want time to look at those. We actually had submitted a search warrant to you, Your Honor, for phone records from the defendant. We had found out that there were some relevant text messages in this case, and we were still waiting for that to come back. We were willing to proceed. And I know on Tuesday I did say that I was ready, but I did not have this reciprocal discovery, and so I would not be in the pursuit of justice if I proceeded without researching this information that he provided.
And then the videos that Mr. Schnipper didn't have, those are custodial or non-custodial interviews between
Those are
police and
those
Mr. McGriff?
Audio.
Those are non-custodial.
It was audio. not
Oh,
video.
audio, okay.
Audio. They're audio, and I thought they were served in discovery, but it looks like they were not.
Okay, but there's certainly material. It's Mr. McGriff talking with the police.
Yes.
Got it. Is it a 2-minute conversation or a 3-hour conversation?
No, there are actually 2 recordings. One is about 20 minutes long and one is about, I think, about 11 minutes long.
Okay, same detective?
Yes.
Okay. Mr. Schnipper, in the docket, I'm noticing now for the first time, you may have mentioned it, but I forgot, you have a motion to dismiss or exclude. Was that predicated on, well, look, if we have to go to trial on date X, I just got this information.
I want to say, I have to look, I've motioned to exclude,
Well, it says motion to dismiss or alternatively exclude.
I think that was based on the October calendar. I need to go back and look at that.
It looks like it. I'm just skimming it now. I think it was that the DNA
Because I didn't.
wasn't back.
I didn't, yeah. So
Okay.
That's moot. That's
Okay, we don't need to worry about that. We do have the DNA results now?
Yes.
Okay, great. So the only thing that the state has asked for from some outside entity that the state doesn't have yet would be phone records if they still exist. More critically, the full state's witness list you got just yesterday. And then there are a couple audio statements that people thought were in the evidence.com link, but they hadn't been included. Tell me, Mr. Schnipper, your leave, if you can pull that up, or I can maybe find leave of absence. You've got an amended one here.
I've got it in front of me.
For the month of December. I've got you're out from December 9th through January 5th.
In Utah, Your Honor.
Okay, that's pretty much the month of December. And then you're back for, are those even work days? A couple work days and then out for another week in January. Okay. All right. It sounds like Ms. Clark, you're not objecting to Mr. Schnipper's request for more time because in the same way you want more time. You want to digest the reciprocal discovery. Mr. Schnipper needs to digest his client's statements and obviously wrap his arms around the witness list. Okay. We will find a time when this case gets tried, if it's not otherwise resolved, but we'll figure something out. Okay. Anything else, Mr. Schnipper?
Yes, sir.
All right, good luck with the mouth.
Oh, thank you.
Mr. McGriff, you remain on bond. Make sure you comply with the conditions of the bond.
Now be excused, Your Honor.
Yes, sir.
Thank you.
Mr. Suttles?
Yes, sir.
Oh, you're here. Great. All right. Mr. Suttles is here, so we can work through that situation. Reynolds is in custody. Mr. Romero made it. Good morning, sir. Ms. Nix, do you have an announcement in Mr. Romero's case?
Yes, sir. I just submitted a non-cross order to Ms. Nelson.
Okay. Mr. Romero, because of the work you've been doing, the state is dismissing your case. You may need to continue to do some of the things you've been doing. I don't know how that's been left, but because of the nature of your case and what you've been doing, the state is dismissing the charges. Your lawyer knows that. She's in another court right now and can't be here, but your charges are dismissed and you will not need to come back here again. Does that make sense?
Yes, sir.
Any questions?
So it's already closed?
I need to sign something, but I'll sign it today. So before you go to bed tonight, it will be closed. Okay? Happy holidays.
Get done.
Thank you, Ms. Nix. Michael Stevens, still here. Good. Okay. I don't need to talk with Mr. Gomez. And someone had come in. You are, sir? Who are you? Say that again? Oh, okay. All right. And no Mr. Jordan. All right, bench warrant for Mr. Jordan.
Yes, sir.
All right, Ms. Clark, I think you are good to go. And we'll figure out what's going on with Chalmers. But Previon and Chalmers are sort of the two that are likely, only one will go, but next week.
Yes, sir.
Probably only one will go. We'll see. Okay,
All right,
thanks.
thank you.
Mr. Rye, I need you to stay because we're hoping to get Mr. Partridge here. Have you and he had any conversations since you and I last spoke just about status?
Yeah, other than what I really.
Okay, all right. Then I'm ready if there are any pleas. Otherwise, I can sit tight here if lawyers need to talk with their clients. Ms. Rios, do you need to chat with your clients?
Yes, Eric and Lisa can go. I already explained.
You talked to him? Okay.
And I'm going to talk to Dr. Prudence and Ms. Nix just to get that.
Okay. And Ms. Wood is talking with someone right now? She disappeared. Okay. Ms. Rutland, I guess you're here because Ms. Wood is talking with Mr. Reynolds to see if this is something that's working out. Okay. And is this the case where you said the investigator, yeah, it may have been Ms. Nix who said it, but we need to start a little late if we're going forward on this. Okay.
Yes.
All right. Morning.
How are you? Good. Judge, are you in the middle of something?
I was in the middle of waiting for you to ask me what's going on.
Can we, do Mr. Settles, please, so we can get back to work?
Let's do it. I'm waiting for a couple of defense attorneys, and then I know Ms. Rios is trying to work some things out. So let's do Mr. Suttles. Mr. Suttles, if you'll come on up to the podium, please.
Itty bitty little disc.
All right, I need to make sure I've got all the cases we're covering here. So let's go on the record. I know we're on the record with 23 SC 188162 and 23 SC 191603. The first is a drug case. The second is a theft by receiving case. And I believe our third case is 24 SC 004521.
Yes.
Everyone agrees? Okay. Mr. Suttles is here in court with Ms. Wood, his attorney. Ms. Nix is the prosecutor on all three cases. And Mr. Suttles, it's my understanding that you're prepared to enter a plea into all three cases. Is that right? Okay. In just a moment, Ms. Nix is going to put you under oath. Once you're under oath, you'll need to answer all of her questions and mine truthfully and completely. I will do my best to answer your questions completely and truthfully. But you got to let me know if you have any questions. So if at any time someone says something that doesn't make sense, or it's not going the way you and Ms. Wood had talked about, or wait, what? 20 years to serve? Then stop us and say, I'm confused, or I need someone to explain that. And it may be that you and Ms. Wood step back and speak in private. Maybe it's something that I can answer. Will you do that? Sure. Okay. Ms. Nix, when you're ready.
Thank you, Judge. Mr. Suttles, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your true, correct, and legal name. Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Is there a medication that you normally take that you have not taken or been given today? How old are you?
40.
How
As
far have
in
you,
today's your birthday? Oh, I don't know this is how you intended to spend your birthday, but happy birthday.
how far have you gone in school? Is English your native or dominant language? Do you understand that you've been charged with the following offenses? In 23 SC 188162, possession of marijuana with the intent to distribute, possession of a firearm during the commission of a felony, and possession of a firearm by convicted felon. In 23 SC 191603, theft by receiving stolen property. And 24 SC 004521, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by convicted felon. Do you understand that you have the right to plead either guilty or not guilty to these charges? Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial? Have you had the opportunity to review your rights with your attorney? Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge? Do you need more time to discuss the case with your lawyer, Ms. Wood? Are you satisfied with her services? Ms. Wood, do you waive a formal reading of the indictments for purposes of the plea? And do you waive any and all defects in the indictments for purposes of the plea? Mr. Suttles, do you remember having been arrested on each of these charges? Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today? Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? In 23 SC 191603, count 1, theft by receiving stolen property, state recommends an 8-year sentence that you serve 5 months with the balance on probation. The defendant has 157 days of credit in that case. In 23 SC 188162, state recommends as to count 1 an 8-year sentence that the defendant serve 9 months with the balance on probation.
So you said 9 rather than 5. You meant a different amount.
Yes, sir.
Okay.
9 months. The defendant has 275 days of credit in that case.
Okay.
As to count 2, state recommends 5 years suspended to run consecutive to count 1. Special condition is no violations of the law. Count 3, 5 years that you serve 9 months concurrent with count 1 with the balance on probation. In 24 SC 004521, count 1 aggravated assault, state recommends a sentence of 8 years that you serve 9 months with the balance on probation. Defendant has 267 days of credit in that case. As to count 2, state recommends 5 years suspended to run consecutive to count 1. Conditions is no violations of the law. And count 3, state recommends a 5-year sentence that you serve 9 months to run concurrent with count 1 and the balance on probation. Conditions in all 3 cases is that you forfeit all seized property, have no contact with Pamela Land or Frank Jacobs Jr., complete 200 hours of community service, submit to a drug evaluation and any treatment, restitution in the amount of $500 to Pamela Land, and you must be full-time employed or full-time school. Do you understand that's the state's recommended sentence? Do you understand that the court is not required to accept the state's recommended sentence? Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively? Judge, I don't believe, I don't have notes if his final plea rights in the 2 cases on the calendar have been preserved.
I think it would say if they were. I don't know, Ms. Wood, if you have different information.
It was only the 3rd case.
Okay. All right. So do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today in 23 SC 188162 and 23 SC 191603, you do not have the right to withdraw your plea of guilty? But if the judge orders a sentence that differs from the negotiated plea you're expecting today in 24 SC 004521, you do have the right to withdraw your plea of guilty. Are you currently on probation or parole anywhere? Do you understand that your probation or parole may be revoked upon you entering this guilty plea today? Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? Do you understand that while you're on probation, you must follow all the special conditions of your probation? Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence? Do you understand that you are not allowed to possess or use a firearm while on probation? Are you a United States citizen? Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm? Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 10 years? Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future? Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime? Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses? Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial? Is it your decision to waive these rights and enter a guilty plea today? Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to enter a guilty plea because you are in fact guilty? How do you plead to the charges of possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony, and possession of a firearm by convicted felon in indictment number 23 SC 188162? How do you plead to the charge of theft by receiving stolen property in indictment number 23 SC 191603? And how do you plead to the charges of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by convicted felon in indictment number 24 SC 004521? Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you? Do you understand that you have only a limited right to appeal this guilty plea conviction? Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? Do you understand that since these are felonies, you have only 4 years from today to do so? In 23 SC 188162, had this case gone to trial, the state believes the evidence would show that on or about February 22nd of 2021, officers conducted an investigatory stop on a stolen vehicle. The driver was taken into custody, and an inventory search was conducted on that vehicle. Marijuana in an amount that was over 400 grams, which is with the intent to distribute, and 2 firearms were found. The defendant is a convicted felon. In 23 SC 191603, on or about May 14th, 2023, officers initiated a traffic stop on a...
What are the last, I think you said 191, but I'm going by the last 3.
Oh, sorry, 603.
603, all right, I'm there. This is the RAV4 case.
Yes, sir.
Okay.
On or about May 14th, 2023, officers conducted a traffic stop on a vehicle that they got a flock hit for it being stolen. The defendant attempted to drive off, but officers were able to stop the vehicle. The defendant took off running on foot and found and was apprehended shortly after by the officers. That was a RAV4 vehicle valued at over $1,500.
think it said 25,000 in the indictment.
25,000.
Yeah.
And that occurred in Fulton County. In 24 SC 004521, on or about December 29th, 2021, the officers responded to an armed person call and spoke with Frank Jacobs Jr., who told officers that the defendant struck him in the back of the head with a handgun and then pointed it at him, threatening to kill him. The defendant was identified by the victim picking him out of a lineup, and that occurred in Fulton County. The defendant does have 5 prior felonies. All are drugs or property. 1 in Clayton County in 2022. The rest are in Washington. The defendant was arrested on each of these cases after he was released for a previous one, so he has actually served a total of about about 2 years in custody.
Right, I'm seeing
Total.
he had 275 days in connection with the marijuana car stop, and then got out, and then would have picked up in about a month the ag assault, which is the newest indictment, but it just took a while to indict, I guess. And then that was 267 days, and then was out for a few months and picked up the stolen car case. Okay. 275. The restitution is for Ms. Land and the stolen car case?
Yes, sir, and that is her insurance deductible for the damage to the vehicle.
Got it. All right, so Mr. Suttles was driving it, not just a passenger in it. And in the case ending in 162, the marijuana after the traffic stop, you said there were 2 guns found. Do you know if there were other people in the car, or was just Mr. Suttles, or you can't tell from what you've got?
It was just Mr. Suttles so far as I have.
And then the most recent indictment, which is not the most recent event, it's the second most recent event, December of 21, where Mr. Suttles supposedly struck this guy and he picked him out of a lineup. Was it a stranger situation? Do you know, or?
It was a sort of knew of kind of, he knew his first name when officers arrived, but didn't know his last name or any other identifying information, and was able to get his last name by talking to other people.
Okay.
And then that is how the officers put him in a lineup, which then the victim picked him out of.
Got it. Okay, thank you. Let me see if we have Ms. Hardy from pretrial. Good morning.
Good morning, Your Honor.
How are you?
I'm good.
Can you tell me about Mr. Suttles' criminal history, please?
This defendant has a total of 32 arrest cycles with arrests out of Georgia, Missouri, Washington, and Oklahoma. There's a felony conviction out of Georgia in 2022 for entering auto. Out of Washington, 2017, burglary of a residence. 2016, taking a motor vehicle without permission. There was 1 probation violation in 2017. Nothing further to report.
Thank you, ma'am.
You're welcome.
So, Ms. Wood, Mr. Suttles has been a busy guy, although admittedly, some of this is old news, and we're dealing with the usual Fulton. Now, 3.5 years later, he is in court admitting responsibility for things for which combined he's spent almost over 2 years in jail. They're just not connected with sentencing today.
So my math is correct, he's done 771 days here in Fulton. And I did want to let the court know, I don't know if he's actually been out in between those stints very much, because he does have Clayton County probation, and I know a couple of times he was released to Clayton County to deal with a hold there.
Okay.
So I did just want to let the court know that. Judge, he is 40 years old as of today. Happy birthday, Mr. Suttles. He just started working at Tip Top Poultry in Marietta. He's very proud to have that job at the chicken factory. Judge, he is working on getting himself stabilized. He is participating in and living at Must Ministries in Cobb County. And Judge, from what I know from that program, they don't play around. So I'm hoping that that plan and placement will cover the drug evaluation and treatment portion of probation. The only other thing that I would ask is that the court consider waiving probation fees for the first few months, just so he can continue to get his life together and hopefully maintain the employment. I am asking for a restitution hearing, and if the court sees fit, I would ask for a behavioral incentive date as well as a reduction in the community service hours, although I do understand that he will have the whole time of probation to complete that, but he is a little concerned since he's just now gotten his new job and is working through Must Ministries Judge.
Got it. Mr. Suttles, tell me what's been going on in your life that's different. Well, let me take a step back. The last day I see you in custody from looking at the screens here is in April. You got out in April from the arrest. I don't know what the arrest was for. There's a January, right into January, you got booked into the Fulton County Jail. I think that was from Clayton. You may have been transferred from Clayton because you were dealing with a revocation. So have you been out since April? Okay, tell me what's been going on in your life since April, because that's now good 7 months.
I just been trying I'm really trying to actually apply myself and live life instead of destroying. My rap sheet don't look good.
It doesn't. I've seen worse. You're 40 and you have 30 cycles. I get guys who are 25 and they've got 30 cycles. So you at least spread yours out over a couple decades.
I went through some tough times back then. I just flew off the handle. No excuses. I'm a grown man. I take responsibility for my actions. But right now, that's in the past. I'm looking forward to getting my own place, getting on my feet.
How long have you been at Must Ministries? Just 1 week. Where were you before that?
Another homeless shelter in not Marietta, but handicap.
Okay. Do you have family in the Atlanta area? What brings you, I know you've been in Washington and Oklahoma and Missouri. What brings you to Georgia?
My mom was here in 16.
Okay.
I came from Washington State in 16 here and kept my nose clean. As soon as I got here, got a job, started working. I think the first 3 years, stayed in the house and do nothing, just went to work.
Yeah.
And everything got derailed and I started doing that stuff.
Is your mother still living, just not in Georgia, or she's passed?
She's still here. She's still with us. She's just not in Georgia. Right now, me and my mother is not seeing eye to eye, so I don't know exactly where she is.
Okay. Well, she might have gotten a little frustrated with you.
As mothers do.
Yeah.
Jeff, I may just interrupt.
Yeah.
He found, when I met him, he was unhoused and he found the shelters of his own volition. And he also, anytime his number changes, he calls to let me know. So I think he should be commended because
Good.
you have seen several of my clients that do not have it as together, Mr. Suttles.
Right. No, Mr. Suttles seems right now to have turned a corner, and we're having this bizarre. You have to condense everything into 10 sentences. You don't know me, I don't know you, but I'm trying to get a feel for what will work to give you some structure so that your fifth decade, 40 through 49, is better than maybe some of the previous decades. I'm sure you're tired of it, getting locked up, and it sounds like you've basically been locked up, give or take a little bit, the last 3 years of your life, and that's no good. But the stuff you were doing is no good either. And so I need to be thoughtful about the people who are around you and make sure no one else gets knocked on the head with a gun. if you were to put your finger on what was going on during these worst years for you, would you say that it was drugs or mental health or both, or you're just a bad guy, or what do you think it is?
First off, I want to say that Mr. Jacobs lied. I did not have a pistol. I did not hit him with the pistol over his head. He hit me, I hit him back. That's what happened.
Okay, and this
I
was.
just wanted to say that.
No, I hear you, and this is the time to air that out, and you spent almost a year of your life in jail because of whatever he said. We don't have a video of it. Clearly you guys knew each other and it was not a happy relationship. And he's not here. But setting that aside, you were clearly getting mixed up with law, marijuana, guns, this and that. What was going on? I mean, it could be because you couldn't get a job. It could be because you were drinking too much. And it's just not for me to suddenly then say, oh, it was that, you're going to jail. I want to have you not ever go to jail again. But if you aren't telling us, hey, the real deal is I'm depressed. And what I do, because I don't go to a doctor, is I drink when I get depressed. And if I drink, then I lose my job and then I need to steal stuff, or I have no idea what is behind this. But because I don't know, it's hard for me to get real comfortable that somehow this sentence is going to be different. Because you got a sentence in Clayton and yet you're driving this stolen car. And you can't blame that on this guy who you said hit you first. You were driving the lady's stolen car, you sped away, you ran away. I mean, you were in the wrong. And that needs to not happen anymore. Because if you and I are working together again, it's because you messed up on probation and I'm not going to be interested in Must Ministries and Tip Top Poultry. So talk to me about what you think is behind some of the struggles you've had.
Purely drugs.
Okay.
Drugs and boredom.
Boredom will do it too.
Drugs and boredom.
Yeah, okay.
I can't even sugarcoat it. I can't cut it to you.
Have you received treatment before?
Yes, I'm actively going to treatment. I'm actively going to, I'm trying to do as many AAs as I can and just be in a different mindset.
Okay.
Like back then, I was just super immature mentally. I think those 3 years in really did something for my brain.
Okay. Well, that's helpful to know. I appreciate you sharing that. A possible outcome if you have little hiccups on probation. If you have a big hiccup, if you get arrested for something else, I'm gonna revoke time. But if you are just sort of wrestling with things and it's hard to keep down a job, or maybe you're testing positive, if you have a drug screen through probation, is that I might add a condition to your probation later, not today, that you participate in drug court, so that you've got sort of enforced structure. That's not a custodial program. You would still be able to work and whatnot, but we'll start out with no drug court and see how it goes. But I want you to know that if we're having to work together again and the issue is you're testing positive or you're just kind of flaky with the probation officers, that'll be a sign to me that the personal approach to getting treatment isn't rigorous enough, and we might need to make it a requirement of your probation, and drug court is a pretty well-structured way for you to get that kind of help. All right, anything more you want to add?
No, sir, just 200 hours of community service is a little.
You don't like that number? It's a big number.
I just don't like community service because even if it was 10 hours, I would be.
Kind of the point to not like it too much, but
I just got to the point where I'm working and everything's starting to gel and come together.
Yep.
And I just feel like that would be.
How many hours a week are you working at Tip Top?
I work 7 to 4.
How many days a week?
5.
Okay, so a full-time job. Are you an employee there, or is it through a temp agency? Great. So you maybe are on a probationary period and then you'll start getting benefits, or how does that work?
Everything came at the same time.
So you have benefits?
Yes, sir.
How'd you get the job?
I was just asking about work, and the counselor at Tip Top told me, or the counselor at Must Ministry told me about TikTok.
Okay.
I called them, they set up an interview, I came in for the interview and got hired.
And you think that's a job you'd keep for the time being? It's not a forever job, but it's also you think so?
Oh, I know.
Whew, working in a poultry facility is,
It's not the most glamorous job.
no, but it's not about glamour, it's about
It's about the money.
paychecks, my friend.
Right.
Okay.
Gotta get a roof over my head.
Yep, I hear you. And that's more stability. You know, when working with people in drug court, step one is let's get you something stable, and it's a stable paycheck. Do you have direct deposit, or they put it on a card, or?
Right now, I got a lot of stuff going on with my mobile bank. So I just had them put it on the card.
Okay.
Go open up an actual bank account.
Do that. It's harder to spend it that way, and you would spend it on necessities rather than, hey, this card has $700 on it. Let's go do something we shouldn't do with $700 on the card.
See, that's something that I can't say I'm struggling with. I struggle with it. And I've overcome that because I've had money in my pocket numerous times since I've been out. And every time I've always chosen like that.
Good. Well, maybe 40 is your magic year.
I should hope so.
Well, I think we all do, because you've got a lot riding on it. It is not common that I take a plea in 3 different cases and the end result is probation, but I'm mindful, and Ms. Wood has emphasized it. You've actually done a lot of the time you would do for these things if we were able to, as a court system, get offenders in court closer in time to the offense. Then it would be, yeah, you're going to serve a year, but you've already served the year. And there's not a whole lot gained to say that year you served, I'm going to ignore and make you serve a different year now. And it seems like that collective 2.5-ish years or whatever it's been has had some deterrent effect on you because you don't seem to want to go back. All right. Mr. Suttles, I find there's a factual basis for each of your 3 pleas, and that your pleas are knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood all the things that we've discussed. Do you agree with both those? All right, I'll accept your pleas in each of the 3 cases. Ms. Wood, can someone from my office sign your name? I think one of these is an accusation, but the 3 charging documents. Ms. Nix?
Yes, sir.
Mr. Suttles, is it okay if we electronically sign your name indicating your guilty plea on each of the 3 charging documents? We will do that. I am not sentencing you pursuant to the Probation Options Management Act, which means any issue you have with probation, I want to have come back to me. I hope you have none. But even if it's like a little minor, I missed a meeting or I had a couple positives, I just want to be in that loop so that we're keeping close tabs on getting you more structure sooner rather than, oh, he got locked up again. And then just the consequences are worse for you. If you get locked up and it takes 2 months to sort this out, Tip Top's filled your position. And that manager's not gonna want you back because you're not really, man, you just get arrested and then I got an empty spot on the line. And who's gonna be doing that stuff? So, all right. Do you have a weapons carry license? All right. You are on probation now out of Clayton County. Ms. Wood, you've talked with Mr. Suttles that 2 of these should have no impact because the actual incident, the marijuana and a gun and whatever fight he had with the gentleman, those incidents occurred before his plea in Clayton. Tricky one is going to be the stolen car. And so that could have some blowback for you. Okay. Now, all your probation can be supervised in one place. So you're not going to need to go to Clayton and go to Fulton. It will be driven by where you live. And so if Must Ministries is in Cobb, then you're going to have a probation officer based out of Cobb. And he or she will be watching you in connection with our 3 cases and your 1 Clayton case. But it sounds like you're going in eyes wide open. There could be probation consequences in Clayton for your plea in the stolen car case. You understand that? Okay. Ms. Nix, in at least one of the cases, the state filed a recidivist notice. Are you withdrawing that for purposes of the plea?
Yes, sir.
All right, Mr. Suttles, in 23 SC 188162. That's the February 21, got pulled over, had marijuana and some guns in the car. I'm sentencing you on count 1, the marijuana count, to 8 years to serve 9 months with the balance probated. Count 2 is 5 years. It has to be 5 years. It has to be consecutive to count 1, but I'm going to suspend that. And I will make as a special condition of that suspension that you obey the laws of Georgia and any other state. Count 3 is 5 years to serve 9 months, balance probated. That will run concurrently with count 1. So the overall sentence is 8 years to serve 9 months, but you'll get credit for the little more than 9 months you already did. It means you'll be on probation for 7 years and 3 months in that case. I'll talk about conditions of probation in a minute. In 24 SC 004521, which is the December 2021 incident where you and that gentleman got into a fight, I am sentencing you on count 1, which is aggravated assault, to 8 years to serve 9 months, balance probated. Count 2 is 5 years suspended, consecutive to count 1, special condition of suspension, obey the laws of Georgia and all the other states. And then count 3 is 5 years to serve 9 months. That'll run concurrently with count 1. And again, you'll get credit for the different 9 months you did. So there's 2.5 years, a year and a half that you've done. And finally, in 23 SC 191603, and that's the most recent of these 3. That's from May of last year, so a year and a half ago. That's the stolen car. No guns, no one got hurt, but you had taken someone's car. Your sentence in that case is 8 years to serve 5 months with the balance on probation, and you'll get credit for the 5 months you served in that case, which gets us to 23 months total that you served across these 3 cases. Now, for conditions of probation, what do you think about getting your GED? Is that something you think you could do, or, man, I'm 40, I do not need to learn how to add again?
I don't want to learn how to add again, but
Yeah.
when I learned that putting in letters into the numbers and said that's a number, I quit.
Okay. So I'm gonna put in a condition that you get your GED. I want you to know you will never get revoked because you tried and it didn't work out. Where you'd get revoked is if you say, I'm not interested. It's more important that I take the feathers off the chickens. You don't need to get your GED tomorrow. You don't need to get it next month. But I'm going to have as a requirement of probation in each of your cases that within 3 months, you enroll in a GED course. And Must Ministries can help you with that. Not that they'll teach it, but they're going to say, great, that's betterment. You getting a GED makes you more employable, whether it's getting a promotion at Tip Top or doing something else. And so you're going to try it out. And I will tell you, if you get into it and they tell you that the letters are numbers and it just is a crash and burn situation, all right, no harm, no foul, but you tried. And so we're going to try that out. And the requirement is that you must enroll in a GED course within 3 months. In each of the 3 cases, you will forfeit anything that was seized from you. And there may be some cases where they didn't seize anything from you. And by now, my guess is they've destroyed most of it. But don't go back to the officers saying, hey, those guns you took from me, I want back. First of all, you can't have a gun. That would be the dumbest thing you could do. But if they also, you had a necklace and they took that, everything you had is forfeited. You're moving forward, not looking backward. No contact with the victims in your case. So Ms. Land, the owner of the RAV4, and then the gentleman you had the fight with, he goes his way, you go your way. We'll set down a restitution hearing should the state want to move forward with restitution in the case ending in 603. I am going to require you to submit to a drug and alcohol abuse evaluation. And that's more so to get a professional's recommendation as to what treatment you should get. And that person may say, you were doing all the right things. Keep going to those AA meetings and go to the counseling sessions at Must Ministries or whatever you're doing. But they may say, you know what, not AA, you need to go to NA or whatever. So you'll do that evaluation, and then any treatment that's recommended becomes a condition of your probation. And that's again meant to help keep you on the rails, which you tell me you want to do. And I will waive your probation supervision fees for the first 3 months as you continue to earn the good money and bank it. I am going to require you to do 150 hours of community service. You don't have to do those day one, but that is work you're going to do out in the community. I'll tell you this, if you're passive about it, probation is going to say, hey, here's an opportunity to pick up trash. You can go do that. But if you engage with folks at Must Ministries or other places, they may say you can work in a food pantry. And it's much more interactive, and you may find it more fulfilling. It's never going to be super fun, but again, that's not necessarily the point of it. So let me check one thing here. Not able to do that, I don't think. All right. And lastly, it will be a requirement of your probation that you are working full-time. That doesn't mean if you lose a job, you're suddenly in violation of probation, but then it means that you need to show your probation officer, I'm looking, I'm applying here, I'm applying there. Finding jobs won't be easy for you. It probably hasn't been for a bunch of years because of your criminal history. That's just all the more reason to be on point with your current job because you got one. And a job in your hand is worth a whole lot more than 6 jobs on a bulletin board. Okay? Mr. Suttles, we're taking a little bit of a flyer on you, but you'll be back if it doesn't go well. I hope it does go well. You've got something stable right now, and I hope you're able to maintain that. Maybe that 40 years of wisdom will help you with that. And rely on the support you've got at the housing you've got and all that. Ms. Officer Evans, do you have reporting instructions for Mr. Suttles? He may already have a probation officer.
Yes, Your Honor. Mr. Suttles, are you at Clifton Men's Ministries?
No, ma'am.
What's your current address?
It is 1297 Pillsbury Road.
Pillsbury?
Pillsbury.
Can you spell that for me?
It's BE. I'll send it to you.
Okay. And what county is that in?
Cobb.
Cobb?
Yes, ma'am.
Okay, one moment. You're going to report to the Cobb County Probation Office. That's at 590 Chalmers, COMMERCE, Park Drive, Suite 102, Marietta, Georgia, 30060. Telephone number 770-528-4923. And that report date is November 28th, 2024 at 9:30 a.m. Failure to report may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
That is.
Hold on
Thank
one
you,
sec.
sir.
There may be a problem with that date. What was the?
The 28th is Thanksgiving, so I don't know if they're open that day.
The 28th?
Yeah, what was the date you gave?
November 28th?
Yeah, that's Thanksgiving Day.
Oh, it is. Oh, I'm sorry. December 5th. I'm sorry. At 9:30 a.m.
Thank you.
Yes, ma'am. Good luck to you, Mr. Settles.
Ma'am?
She said, good luck to you.
Oh, thank you.
Thank you, Judge.
You're welcome.
All right. Happy birthday.
Off the tip top. Happy birthday.
Mr. Burton, you're the most uniquest judge I've ever seen.
Well, since you've seen a lot of judges, I'll take that as a compliment. All right, Mr. Partridge, good morning, sir. How was municipal court?
It was good, Judge.
Were you there as a lawyer or as a customer?
Lloyd.
Okay, that's always a better way to be there.
Absolutely, Judge.
Mr. Rao's gone.
He stepped out. We did talk a little bit, Your Honor, and wanted to approach essentially regarding a less than trial resolution.
Okay, so when he comes back in, we can do that.
Yes.
Excellent. All right, let's see what else we've got. That is Chalmers. How about Michael Reynolds? Update on that, Ms. Wood, or you've been busy because you just,
I need to speak to him.
okay, let's do that. Ms. Rios, how about Mr. Stevens? Mr. Stevens, come on up. Ms. Nix, are you able to pivot or do you need a break?
As I find them.
Let me know when you're ready.
One moment.
Sure.
Okay, I'm ready.
All right. So we're going on the record in position 19. It's 24 SC 001 837, State versus Michael Stevens. Mr. Stevens is here in court with his lawyer, Ms. Rios, and Ms. Nix is handling this for the state. Good morning, Mr. Stevens. Sounds like you're ready to enter a plea in your case. Is that correct? All right. Ms. Nix is going to put you under oath. She'll ask you a bunch of questions and you'll need to answer those truthfully and completely and let me know if you've got any questions of your own, okay? All right, Ms. Nix, just before we start, not on the record, Mr. Rao, Mr. Partridge and I spoke real briefly. He's going to talk to Mr. Chalmers right now. He said, maybe non-trial resolution, but we need to talk to you. So he'll be back. And when we're done with this plea, we can see what's going on. All right. Ms. Nix.
Thank you, Judge. Mr. Stevens, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? You can put your hand down. Please state your true, correct, and legal name. Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Is there a medication that you normally take that you have not taken or been given today? How old are you? How far have you gone in school? Is English your native or dominant language? Do you understand that you've been charged with the following offenses? Count 1, aggravated assault. Count 2, possession of a firearm during the commission of a felony. And count 3, possession of a firearm by first offender probationer. Do you understand that you have the right to plead either guilty or not guilty to these charges? Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial? Have you had the opportunity to review your rights with your attorney? Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge? Do you need more time to discuss the case with your lawyer, Ms. Rios? Are you satisfied with her services? Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I do waive the purpose.
Mr. Stevens, do you remember having been arrested on these charges? Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today? Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to count one, state recommends 5 years probation. As to count two, state recommends 5 years suspended to run consecutive to count one. And as to count three, state recommends 5 years probation concurrent with count one. Conditions are that you complete 100 hours of community service and complete anger management and no violent contact with Baron Malcolm. Do you understand that's the state's recommended sentence? Do you understand that the court is not required to accept the state's recommended sentence? Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively? Does the defendant still have his final plea rights, Your Honor?
I don't think so, although I'm confused by, we'll talk about sort of what's in the docket when he was arrested in connection with this.
I couldn't
You don't
tell.
have a bond. I think that's part of the weirdness with this case. I think this case got dismissed
At prelim, yes, sir.
at prelim. Okay, that would explain. I was just looking at his time in jail and for some reason, I know we're getting off the rails a little bit, but we'll bend back. This supposedly happens in November of last year, but then you're not arrested until January of this year. You spend a couple months in jail, then I guess the charges get dismissed. You finally have a prelim and a magistrate, either the officer doesn't show up or the officer does a bad job or whatever, but the charges get dismissed. Then you get indicted. You don't have a bond, never good. But then you didn't show up for final plea. But then it was okay that you didn't show up for
They
final
called me
plea.
the same day.
Okay,
And then,
we didn't do a bench warrant.
or you set it aside because I had them come like the following court date. week.
Okay, all right. So we really never did final plea, so I guess technically he's got his final plea rights.
Okay. Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, you have the right to withdraw your plea of guilty? Are you currently on probation or parole anywhere? Do you understand that your probation could be revoked based on your entering a guilty plea today? Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? Do you understand that while you're on probation, you must follow all the special conditions of your probation? Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? Do you understand that you are not allowed to possess or use a firearm while on probation? Are you a United States citizen? Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm? Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years? Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future? Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime? Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses? Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial? Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to enter a guilty plea because you are in fact guilty? How do you plead to the charges of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by first offender probationer in indictment number 24 SC 001837? Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Do you understand that you have only a limited right to appeal this guilty plea conviction? Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? Do you understand that since these are felonies, you have only 4 years from today to do so? Judge, had this case gone to trial, the state would expect the evidence to show that on or about November 4th, 2023, the defendant and his brother-in-law, Baron Malcolm, were arguing at the apartment that Mr. Malcolm lived with the defendant's sister and their children. I'm not sure if all of them were both of their children. The sister was leaving and heard a gunshot. Mr. Malcolm was shot in the shoulder. Mr. Malcolm refused to give a statement to law enforcement, but Mr. Stevens' sister did say that she believed he had a handgun. The defendant was on first offender probation at the time and was in possession of a handgun during the commission of the felony, and was on first offender probation in 16 SC 141781. And that occurred in Fulton County.
So were there just 3 people around? The sister, who wasn't the shooter, and Mr. Stevens and Mr. Malcolm, and Mr. Malcolm got not just shot at, but hit in the shoulder?
Yes, there were some children around, but I don't believe they were actually in the apartment when this happened. I think they had just left.
Okay, and your recommendation is probation for someone that, if you rely on the reports you have, actually shot not just at someone, but hit someone?
Judge, based on the relationships among all these people in my discussions with the victim, who I believe is actually here and may want to make a statement.
Mr. Malcolm is here?
Yes.
And just to preference, he's in crutches that had nothing to do with this incident. He injured himself at work, but he's here today.
Okay, I look forward to hearing from him. Okay, all right. That's it?
Yes, sir. So the state's, I guess, really accepted the defense's offer due to the difficulties of proving this case. The fact that Mr. Malcolm has not given a statement to law enforcement even on the day this happened. And its evidence is that someone got a gunshot and the defendant's sister heard a gun being shot, and it was the only 3 adults in the apartment.
Okay, got it. Thank you. Ms. Hardy, criminal history information on Mr. Stevens, please.
This defendant has 3 arrest cycles out of Georgia. The case that they're on first offender treatment, they're on first offender was 2016. It was criminal attempt to commit a felony, aggravated assault, and possession of tools for the commission of a crime. Nothing further to report.
Thank you. Officer Evans, how much time is left for Mr. Stevens on that case?
10 months and 3 days, Your Honor.
All right, thank you.
And he was also on unsupervised probation, or has been on unsupervised probation on that 16 SC case.
Okay. I know he had a revocation in front of Judge Cottle in 2019, 5 years ago. But since then, you're saying it has become unsupervised.
Yes, Your Honor.
Okay.
Judge,
All
when
right.
the defendant was arrested for this case, there was a petition filed, but it was dismissed when the case was dismissed at prelim.
Okay. All right. And was it dismissed because the officer didn't show? Okay.
Yes, sir.
Thank you. Ms. Rios.
I've been doing this, I know.
Mr. Peters is 26 years old. He currently works with his uncle, who works with the landscaping company. His uncle did write a letter. He signed it saying that he works working for JB Landscaping, and he calls Mr. Stevens to work 3 to 4 days out the week, and he pays him $70 to $85. We did discuss what he wanted to do with his life. He actually enjoys cooking and thinks that he wants to possibly go to culinary school. He wants to get his GED. Look into the things. So I've explained to him that, you know, this case, he doesn't have an extensive criminal history. He has these 2 cases and he can do stuff with his life. He's young, he doesn't have any children, and he plans to do that. It seems like he's had a good relationship with his probation officer, and I do think he's a good candidate for probation. When I initially called him about the case, he actually had his probation officer call me because he thought this case was dismissed. And so I was talking.
It was dismissed.
And so it seems like they had a good working relationship. He hasn't had many violations. He was on non-reporting. And he was sentenced 10 years ago, almost 10 years ago. He's pretty much almost done. He only had less than a year left that he has on probation. I've discussed with Ms. Nix, and we agreed that we would ask for to have a probation revocation hearing and terminate the balance. So he's just on this probation. I've spoken with I spoke with him, and it seems like whatever happened to that room was both of their faults, and said it was an accident, and he maintained that he didn't want to go forward with this case. They seem to have a good relationship. He's close with his sister and their kids, and they just want to put this behind him. He is accepting responsibility with, you know, having a gun around, given that he was on the first offender probation. So I did explain to him that the other 2 charges would be a little complicated than the aggravated assault to prove. So that's why we think this resolution is a good one. And so I'm asking that you accept the plea, and also asking that there's a behavioral incident date of 5 years. If he has no other charges, no arrest, has employment, gets his GED, and all the other conditions, that he could be removed after 5 years of probation.
Okay. Who's the other person that came with Mr. Stevens today?
That is
Okay. So Mr. Malcolm is your sister's. Okay, and he was living with you and your sister last year? Right, I mean, the 3 of you were all living in the same place. Did you have your own room? The 3 of you shared a room? Okay, so you were on the couch, you were basically on their couch or whatever was there, and they had their own room. Is your sister still with Mr. Malcolm? Okay, do they still live in that same place? Do you still live with them? So what happened?
It was basically like we was both just drunk, and I was playing with my nephew and stuff like that.
Your nephew would have been how old?
I don't know.
Well, 1 year old or 5 years? Like, could he walk and talk?
Yeah, he's like probably like 10, 11,
Back, I guess this is only a few months ago, but when this happened, he was,
probably like 10.
okay, we'll call it 10. So you were playing with him?
Yeah, I was playing with him while he was playing on the game and stuff, and he basically got mad at me and he started crying.
He, the 10-year-old?
Yeah.
Oh, this would be Mr. Malcolm's son.
Yeah.
Got it. And your sister's son. So you're his uncle. All right. So this 10-year-old gets mad at you. He's crying.
And Mr. Malcolm came out, and me and him basically had an altercation, and that's when the kids left and stuff. And I guess it was just like adrenaline and the alcohol that made everything happen, but stuff just went out.
And did Mr. Malcolm have to go to the hospital?
I think so.
Why would you not know? Were you arrested then? No? So why wouldn't you know if he went to the hospital? Where'd you go?
I just left out the house.
Oh, you just left him there bleeding?
I just left out the house, and my sister was already on the phone with the ambulance and stuff like that.
Okay.
That's when I left and stuff.
Did you ever move back in there, or that was the end of your time there?
Yeah, that was it.
Okay, but Mr. Malcolm is here. You've seen him since then?
I ain't personally seen him, but I talked to him though.
Okay, but this is the first time you've seen him since it happened?
And every time I go to court.
He comes to court every time you come to court? Okay. Let's talk about this GED. You were supposed to get a GED back in 2016 when you got sentenced. You got revoked 2 months because you hadn't gotten your GED, and Judge Cottle removed Visions Unlimited, but said you gotta go enroll in your GED. That's 2019. And here Ms. Rios is saying, hey, Mr. Stevens would like to get his GED. Well, that was 8 years ago when you were supposed to get it. Why is it interesting to you now and it wasn't 8 years ago?
I just feel like it'd be better, like, on my behalf, if I did have a GED or something to like stamp on my name. So
Sure. So any reason why when Judge Brasher said you should get it and Judge Cottle said you should get it, you didn't get it, but now suddenly you will get it?
honestly, when the second Judge Carter, I forgot. That's my honest truth. I forgot.
Forgot.
That's when I did start going, but the lady kept trying to help me, help everybody else. She kept trying to make me help everybody else catch up to where I was, and I wasn't trying to do that.
Right. You're not a tutor. You're just trying to get through GED.
Yeah.
Where were you taking it?
It was on. The first one was downtown at the library. It's a big building. I don't know what it's called.
Okay.
And then we moved to Metropolitan at that library. Right there on Metropolitan. And that's what we.
Okay. So where do you stay now?
On MLK, Martin Luther King.
Okay. In an apartment? And who is in the apartment with you?
My sister, I mean, my girlfriend and her.
Okay. Not your sister.
No.
And the work you do is with, did you say it was with your uncle?
This is with my uncle. He works for somebody. And he called me every time they need help.
Okay. When they need an extra guy, you do that? On a typical week, how much is that?
I say about at least about $300.
$300?
Yeah.
I was thinking time. Like how many days a week do you typically? Okay.
Didn't know it was raining.
How long have you been doing that?
On and off for a couple years.
Okay. Other work you've been doing?
Last job I had was a security job.
Okay. Anything you want to add?
You know, it's behind here.
Okay. Well, I find there's a factual basis for your plea and that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which means if you have a small problem while you're on probation, you and probation will work through that. But if you get arrested for anything, or one other example that I'm going to give you in a minute, that comes back to me. Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Nix?
Yes, sir.
Is it all right, Mr. Stevens, if someone in my office signs the indictment for you indicating your plea? All right. Do you have a weapons carry license? You understand that you can't have a gun. You couldn't while you were a first offender probationer, but now you're going to be, when you leave here today, a convicted felon. So no more guns, period. In theory, if you had made it all the way through your first offender sentence, then when that's over, you're not a first offender probationer anymore. And if you wanted to have a gun, you could. But as of today, going forward, no guns in your household. So if your girlfriend or her grandmother, they got guns in that apartment, they need to get out of the apartment because that's your space too. Does that make sense? Do you have guns in the apartment? No? Okay, good. Mr. Malcolm, how are you doing? How come you're here? Who asked you to be here? The young lady right there? Okay. Are you concerned at all about Mr. Stevens? Like, do you worry about him coming by you and doing anything? No? Are you still with his sister? All right. So, I will follow the state's recommendation, sort of. I'm gonna sentence you on count one to, 5 years to serve 2 months with the balance probated. I'll give you credit for time you served. Count two has to be 5 years. It has to be consecutive. I will suspend that, but I will make as a special condition of those suspended 5 years that you obey the laws of Georgia and all the other states. And then count three will also be 5 years to serve 2 months, balance probated. It'll run concurrently, same time with count one. So the total sentence is 10 years to serve 2 months, within the next 4 years and 10 months probated, and then these 5 years suspended. Just pretty much what was negotiated. It will be a special condition of your probation that you complete an anger management course. You may have no violent contact with Baron Malcolm. You will need to submit to a drug and alcohol abuse evaluation. And if that evaluator concludes that you need any form of treatment, you'll need to get that treatment. You will need to enroll in a GED course within 1 month, and you will need to complete your GED within 1 year. If you are not enrolled in a GED course within 1 month, then that following weekend, you will spend as a guest at the Fulton County Jail. And every subsequent weekend, you will be going at 5 p.m. on a Friday to the Fulton County Jail to be released 5 p.m. on Sunday until you enroll in the GED course. But you get 1 month from today. So it'll be basically middle of December that you need to start checking yourself into the Fulton County Jail on weekends if you're not enrolled in the GED course.
Only if I'm not enrolled.
Correct. If you enroll, which you were supposed to do in 2016 and again in 2019, I guess you did in 2016, but you dropped out. You were supposed to in 2019, but you forgot. This is a friendly reminder that in the middle of December, you'll be spending weekends in jail if you're not enrolled. And once you're enrolled, you have 1 year to complete the GED. Now, if you get into it and the teacher says there's just not a way you can complete all the coursework because you're also working full-time and you need more than a year, I'm happy to modify that. But if you've already done some of it, you seem like a smart guy, you got through 11th grade, you don't need all that much time to get your GED. So I'm giving you a year. And you'll need to complete 100 hours of community service. I think I covered everything. Ms. Rios, I think you're asking for a revocation hearing, so you're waiving any notice requirements. What I will do, Mr. Stevens, in 16 SC 141781 is revoke 2 months, give you credit for the time you served, and suspend the balance in that case. So that case is closed out, and you will be on probation in just one case, and that is this one. And you'll be on probation for 4 years and 10 months. Ms. Nix, excuse me, anything else from the state?
No, sir.
Ms. Rios, anything else? All right. Mr. Malcolm, I appreciate you being here. It was helpful to see you in order to work through this case. Do you have any issues with how this is working out? You think it's a fair sentence? I couldn't hear you. It seems like it's good? Okay. What happened to your foot? What do you do for a living? What happened?
I work overnight. I was going to a dark pad and ran across my foot and I tried to turn around.
A rat ran across your foot? Yuck. So you were on patrol and you were assaulted by a rat and hurt your ankle. Huh. All right. Well, you're not keeping that place safe if there are violent rats running around there. Ms. Rios, anything else?
No, Your Honor, thank you.
Last thing, let me add our trustee probation officer to the screen. There she is. Officer Evans, can you give Mr. Stevens reporting instructions, please?
Yes, Your Honor. Mr. Stevens, what county do you currently reside in? I'm sorry? Okay, you're gonna report to 276 Memorial Drive. That's Southwest Atlanta, 30303 on December 5th, 2024 at 8:30 a.m. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
And Ms. Rios, will you be giving me that contact information?
Yes, I will send you an email with this, just need his phone number.
His phone number and his address. Thank you.
Thank you.
All right, good luck.
Thanks.
So I think all we've got left to sort out for today is Mr. Reynolds and Mr. Chalmers, but Ms. Wood is not out here. Maybe she's talking with Mr. Reynolds. So let's talk about Mr. Chalmers. Should we bring him out?
We can, Judge. I spoke to him a little bit as to where we were and our conversations with the state. We received, after the court's email, we received an email from the state regarding a possible reduction and opportunity to plea from at least the murder count. So we're still going through that and wanted to talk to the court about potentially putting that up in a non-negotiated fashion and to, potentially work through that issue as it relates to that. So Mr. Chalmers is thinking about, what that would look like to him and has given me feedback as it relates to that. So just wanted to talk to the court about the same and make a decision one way or the other.
Okay, well, why don't we bring Mr. Chalmers out and we get all that on the record?
Yes, sir.
Great.
And then, Judge, I just got a few notices for trial. I think one is gonna impact us for Monday potentially, but I'll file the appropriate conflict, et cetera, et cetera.
Okay, notices for here or other jurisdictions?
Clayton County, Judge Malone. in
Okay.
Clayton County, called in a 2021 case. So that might derail me a little bit, but
Sure.
I'm trying to work out a resolution over there as well. So
Okay,
I'll keep the court posted.
great. Yeah, if you can give us that case information so we can coordinate with her as well.
Yes, sir, we'll do.
Okay. Hey, over there by your lawyer, please. All right, let's get on the record in Mr. Chalmers' case. It's 23 SC 187611. Mr. Chalmers is out here with his lawyer, Mr. Partridge, and we have Mr. Rao from the state. And Mr. Chalmers, I just got an update from Mr. Partridge about the fact that the state has offered as a non-trial resolution, a plea, I guess that some reduction, usually they reduce murder to voluntary, but I'm gonna let Mr. Partridge get on the record what he understands the situation is. And then I just want to talk through with you what I see the scenario to be, and that'll give you a little more information, and you can let Mr. Partridge know what you want to do. You can talk privately about it. I'm not going to put you on the spot, but I want to make sure we're on the record at least as to what everyone understands the parameters to be, so that 2 years from now, you're not saying, wait, no one told me this. Okay. So Mr. Rao, why don't you start by letting me know if Mr. Chalmers wanted to enter a plea today, what that would look like from the state's perspective.
Yes, Judge. It would be reducing the lead count of murder to voluntary manslaughter, 20 years to serve. That would be our offer, to court. We have discussed with Mr. Partridge. It would be a global sentence to 20 years.
Okay, all his counts would sort of fold into being 20 years to serve.
Yes, sir.
Okay,
And we indicated that to Mr. Partridge and even entertained, not fully committed on our end, potential to go non-negotiated. In addition to that, it looks like Mr. Chalmers picked up a case in the jail. And it's a case that's actually assigned to Judge Barwick.
probably not for long.
Yeah, right. And so I did discuss with him, that case is on video and it's pretty evident that Mr. Chalmers is a participant in that video.
Is it a multi-defendant
It's
case?
a multi-defendant case. It's an 8-defendant case, but
Okay,
Mr. Chalmers is visibly seen on video assaulting another inmate, holding his head over.
okay,
So there's discussions of potentially, and I think Mr. Francis, at least from the entry of appearance, appears to be representing him.
okay.
So there's discussion of potentially resolving both cases so that one case isn't lingering in the event that we.
Sure. No, I would think if Mr. Chalmers is heading towards 20 years or a number in that range, that other case could be folded into it unless the victim died in the other
No,
case.
It's a aggravated battery, false imprisonment, riot, and suspicion of criminal street gang activity.
The standard that we see again and again there. Okay, all right. So Mr. Chalmers, you understand what the state's recommendation is if you were to enter a plea today. One last thing, let me ask Mr. Rao. Mr. Rao, you were a little vague in lawyerly way. If Mr. Partridge is about to say, hey, Mr. Chalmers would enter a non-negotiated plea so that Mr. Partridge could advocate for a number less than 20. Is that something that can happen? Or if Mr. Chalmers wants the murder reduced, he needs to go along with the state's recommendation, which is not uncommon. I just need to know which, because you did a little bit of a two-step with like, well, there is this.
Something I'm famous for, Judge. No, I think there is an understanding that we would likely be willing to go non-negotiated. The only issue with that, Judge, is that if it does happen today, as opposed to maybe setting a plea date further in advance next week, that the court could withhold sentence, understanding that the court would sentence him in accordance to the agreed upon negotiation or what the court deems is appropriate, just so that the victim's family, with respect to the homicide case, has an opportunity to make themselves heard. It's my understanding, having not spoken to her directly, that she would be very much opposed to the resolution, but given the evidence in the case.
Even the state's reduction and a 20-year sentence, your understanding is she'd be opposed to that?
Right.
Okay. Certainly has a right to be heard, and we could structure it in a way. I would need to have Mr. Chalmers' guilty plea in place so that I know we're not going to trial next week. The sentencing could be deferred to whenever, not too far in the future. And I don't know if this is someone who you could get even virtually for tomorrow, if we were going to do that. But there are a lot of balls in the air, and now Mr. Partridge may have this conflict in Clayton, but that's something that Judge Malone and I can talk about as well. And I just want to give Mr. Chalmers some certainty as to what he's looking at. All right, Mr. Partridge, tell me your thoughts about where we are.
Yes, sir. We had an immunity motion for Mr. Chalmers. We got some additional discovery as well regarding the ballistics, so we understand a little bit more, at least, how the shooting or death occurred in this particular setting and situation. And myself and Mr. Chalmers have spoken about that as well. I do want to correct, on record and in front of Mr. Chalmers, I misspoke. I told him that the state's offer was 20 serve something, but that is not the case. So my apologies as it relates to that, Mr. Chalmers. It is a straight 20 to serve. But nonetheless, Your Honor, we are in a posture where we would want to go non-negotiated if the state is willing to do so. our position as it relates to that, Judge, is we would be asking the court for a time served plea, and not to be disrespectful to the court at all. Mr. Chalmers has a number of medical issues that have been persistent through that of his time in custody, given his size and being considered a dwarf. He has issues with regard to his legs, first and foremost. They are typically bow leg, but he has rods that run through the legs, and those rods have started to protrude. And we're not sure if or when that could have a negative impact on him and he won't be able to walk. In addition to that, Judge, Mr. Chalmers has some rotting in his back area that as well could be detrimental to him. So with the leg issue, with the rod issue, we will be asking for the opportunity for Mr. Chalmers to serve the rest of his time at home so that he can at least get some care as it relates to that, amongst other things that we would argue during the plea if we're accepting it. But nonetheless, there's just some other issues specific to the case, fact specific, Judge, that we are considering as well as it relates to, do we plea or do we, have the jury hear, the opportunity of another self-defense issue as well.
Right.
So, that's where we are at this point as it relates to the same judge, but wanted to at least entertain the opportunity to resolve it, but short of trial.
Okay.
With the reduction, which does not come often, obviously, in these types of cases.
Sure. And I'm sure you've talked to Mr. Chalmers that should he go to trial and he's found guilty, so it's two ifs. If he goes to trial and he's found guilty, murder is either life or life without parole. And depending on what I hear about the nature of the killing, et cetera, life without parole is a legal, non-Eighth Amendment violative sentence. I just don't know enough about your client, his background, or the nature of the killing to say how that would play out. But both of those, life, which would be no parole till at least 30 years, life without parole, no parole ever, are significantly higher than a ceiling of 20 years to serve, because that's what the state would be asking for, and you'd be arguing for less. All right, Mr. Chalmers, I better understand where things are right now. Do you feel like you understand what we just kicked around, or do you have questions for me?
Yeah, I understand.
Okay. I am open to the idea of a non-negotiated plea. So the state would agree to reduce murder to voluntary manslaughter. You know what they're going to recommend? They're going to recommend 20 years. And they'd be free to say, here are the 100 reasons why 20 years is the right number. And I would hear from the family of the deceased. And they would say, that's a ridiculously low number. We're mad that the state's doing that. And they're entitled to say that. I would hear all that. But then I would hear from Mr. Partridge, and he would explain to me why he believes that a whole lot less than 20, I heard him say time served, but you've been in for a while, so it's not like it's 10 minutes, that is a more reasonable outcome. And I'd have a chance to hear from you if there was anything you wanted to add. Ultimately, I would then impose the sentence. The most it could be would be 20, and the least it could be is time served. But whatever number I came up with, that would be binding. You wouldn't get to say, oh, well, my lawyer gave it his best, but you said X, and I'd rather go to trial. So that's the one thing you need to understand. The dice you're rolling, if you go forward with this non-negotiated plea, is that you could end up with 20 years, because that's what the state's asking for, and I might agree with them. You also could end up with time served, because Mr. Partridge will be arguing for that, and I might agree with him. But whatever it is, that's your sentence. It's not a, let's see how it goes. Oh, Partridge, that didn't go well. Now let's get in front of the jury. It's either go to trial, not guilty, you're done. Guilty, life or life without parole. Or it's this non-negotiated plea. Do you feel like you understand your options? Yes? All right. I'm going to let you and Mr. Partridge talk a little bit more. I'm going to stay right here because we need to figure out what we're doing with our one other case. And then you need to let me know, and I'll have you come back out. Mr. Partridge can do the talking, but I want you to be here on the record hearing him say it. Hey, let's do this plea, or, you know what? Let's see what happens on Monday. Assuming I can pry your lawyer loose out of Clayton County, we're ready to go. I'll have jurors. We won't be in this courtroom, but we'll be in another courtroom. And you're entitled to a trial. You've been sitting in jail for a long time. And it is time to do that. Let's let the jury decide if you're not interested in that. Oh, it's too uncertain. You know, I don't know if I'll get time served. I don't want to do 20. So let's let the jury do it. Okay. Any questions for me? All right. Thanks. Ms. Wood, we have one case left to sort out, and that would be Michael Reynolds.
Judge, I think we can make it through a plea today. I think it will be an offered plea. And I did not get all the way through the plea sheet, but I would like to go ahead and go through it before he changes his mind. So just a little.
All right. Here's the dilemma. I'm fine to do that. I have a hard stop in about 25 minutes. So if you still need to talk with him, then we should do it after lunch, because I'll be coming right back here. If you're worried that that would be too much time passing, then we should bring him out right now, but you wouldn't have finished your conversation.
I've had so many conversations with him before today. I'm comfortable doing it. The only thing that I just want to let the court know that in case he does have a question. There's some special conditions the state has that he's probably gonna want me to tweak at the end, that I'll take care of.
All right, let's bring him out. Please. Ms. Rutland, are you gonna do the honors?
I am.
All right.
May I be sure?
Yes, ma'am. I will keep you posted about Previon.
I will be expecting to have a trial. You might bring that one.
Excellent.
It's a hoot.
Yeah, JOYA.
Good morning, Mr. Reynolds. If you'll come up to the podium, please.
So before you get going, may I hop on a Zoom in Bleckley County? And
Sure.
come back and finish my conversation with Mr. Chalmers?
Of course.
Thank you.
We just may reconnect after lunch, but go ahead and do the Bleckley thing. All right. Ms. Rivers, are you ready? Great. We're going on the record with position 10. It's 23 SC 189373, State versus Michael Reynolds. Mr. Reynolds is represented by Ms. Wood, who's standing by his side here in court. Ms. Rutland is the prosecutor. Mr. Reynolds, Ms. Wood told me that at this point, you think you are interested in entering a plea. Is that correct? All right. Ms. Rutland is going to put you under oath. She will ask you questions that mostly involve your rights as a criminal defendant. You should answer her questions completely and honestly. If at any point you've got questions of your own, let me or Ms. Wood know so that one of the two of us can answer them. Will you do that? Okay, I need you to speak up a little bit and we'll move the microphone in your direction so the court reporter can hear you. Ms. Rutland.
Mr. Reynolds, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? Please state your true, correct, and legal name.
You can put your hand down now.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Is there any medication that you normally take that you have not been taken or given today? How old are you? How far have you gone in school?
Did you finish high school?
Yes.
Is English your native or dominant language?
Somewhat. No.
What would you say your main language is?
The main language, my original language is where I'm from. I'm from Jamaica.
Okay,
But I speak English better. I speak Creole.
okay. But you've understood so far everything anyone's been saying. Okay.
Do you understand that you've been charged with the following offenses? in the indictment 23 SC 189373, count 1 aggravated assault, count 2 possession of a firearm during the commission of a felony, and count 3 possession of a firearm by a convicted felon. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Well, I'm not guilty.
So let me walk you through one thing so we don't have to circle around this. There are really three answers you're going to give, three potential answers you can give when we get to that critical question. Because in a little bit, Ms. Rutland is going to say, she'll cover some other things first, but she's going to say, Mr. Reynolds, how do you plead? And you can say not guilty, in which case we'll take you back there and we'll get you a trial on Monday and a jury will hear all the evidence. Number 2 would be guilty. And number 3 would be guilty under Alford, which is code for saying, hey, I want to work this out on the terms that have been negotiated, but I'm not saying I did the things the state did. But it is in my best interest, meaning Michael Reynolds' best interest, to take this deal. That's what we call an Alford plea. And I can accept an Alford plea. And you'll have a chance to say, here's why it didn't happen the way the state said it happened. So it's guilty, I did it. Not guilty, I want a jury. Or guilty under Alford. Those are the three answers. And if yours answer is not guilty, which I fully respect and will honor, then we don't really need to have much more of this conversation because then the state needs to try to convince a jury. Of course, if a jury finds you guilty, it doesn't matter what you have to say about it. They decided. But that's what we're getting at when we're talking about guilty. It's not, did you do it? It's, are you either saying I did it or no, but I've decided it's in my best interest to take this plea? Did that make sense?
Yes, it does.
Okay.
But I thought it was just an interest to take probation.
Well, that may well be the sentence that you get, but in order for me to impose a sentence, I need to make a finding that there would be evidence to convict you if a jury considered it. That's not you admitting to it, but the state would say, hey, we think this is what the evidence would be. And then you'll have a chance to say, that's ridiculous. Here's what the real evidence is. If you want to, you may have no comment on the evidence. But in order for me to impose a sentence, probation, prison, suspended, whatever it is, you have to either enter a guilty plea or guilty under Alford, the best interest plea. And you may not want to do either one of those, and that's okay. But then we're not talking about probation right now. We're talking about let's get ready for trial. So, which is it that you want to do?
We can continue on.
Okay, let's keep going.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, that the state is required to prove the charges against you at a jury trial?
You could repeat that?
Sure. Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial? Have you had an opportunity to review your rights with your attorney?
You can continue on.
Okay. Have you had enough time to speak with Ms. Wood about all of the charges in the indictment, including the facts and circumstances relating to these charges? Would you like any more time to discuss the case? Are you satisfied with your lawyer's services?
I'm all right with what's going on.
Are you sufficiently satisfied that we can go forward? You don't necessarily have to write her a letter recommendation, but you're comfortable going forward with this, Ms. Wood being the attorney at your side. Okay.
Ms. Wood, do you waive a formal reading of the indictment for purposes of this plea?
So wait,
And do you waive any and all defects in the indictment for purposes of this plea?
we do.
The state is unaware of any outstanding warrants related to the charges. Mr. Reynolds, do you remember being arrested for these charges?
Yes. November 6th, I was brought here.
Okay, has your attorney advised you of the minimum and maximum sentence for each of the charges that you're pleading guilty to today?
Well, I wasn't arrested on those charges. I was arrested for failure to appear. That's what I was arrested for. I had a warrant for a failure to appear, not no aggravated assault or anything of that nature.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading guilty to today?
No, ma'am.
So you have been advised of the minimum and maximum sentence?
Well, I'm gonna advise you right now, and if this isn't something you wanna do, I got other things I can be doing, Mr. Reynolds, but aggravated assault is 1 to 20. Possession of a firearm during commission of a crime is a consecutive 5 years, and possession of a firearm by a convicted felon is 1 to 5. Those sentences can be run concurrently, except for count 2, which has to be consecutive. They could be run consecutively. And then I don't know, Ms. Rutland, is there something different because you're involved with the case? Is it not 1 to 20 for the aggravated assault? Is
No,
that-
there's nothing different for
Okay,
this.
all right. So those are the ranges, 1 to 20 for the aggravated assault, plus 5 for gun during commission, and then 1 to 5 for firearm by convicted felon. So the most it could be is 30 years. If I sentence you to the maximum and ran everything consecutive. And the least it could be would be 6 years, 1 plus 5, but that could be suspended, it could be probated, doesn't necessarily, none of these involve a mandatory term of incarceration. You understand? All right.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? For count 1, aggravated assault, 5 years to serve 6 months. For count 2, possession of a firearm during the commission of a felony, 5 years suspended. And for count 3, possession of a firearm during by a convicted felon, 5 years concurrent. Do you understand that? Okay. There are also special conditions of no further contact with the victim, 300 hours of community service. You must maintain employment, full-time employment or enrollment in school, and you must provide a written letter of apology to the victim. Do you understand that?
Yes, ma'am.
This is what the state's recommending. This isn't the sentence I'm necessarily imposing. This is what the state's recommending. You understand? Okay.
Do you understand that the court is not required to accept the state's recommended sentence? Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that if you plead guilty to the charges today, that the court also has the right to run those sentences consecutively or one after the other? Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, does he have the right to withdraw his plea?
He does not.
Okay. That you will not have the right to withdraw your plea of guilty? Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? Do you understand that if you are on probation, you must follow all the special conditions of your probation? Do you understand that if you fail to follow all the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence? Do you understand that you are not allowed to possess or use a firearm while on probation? Are you a United States citizen? Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm? Do you understand that by receiving, possessing, or transporting a firearm will result in new criminal charges for which you can face a sentence between 1 and 5 years? Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future? Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime? Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defense? Do you understand that by pleading guilty, you are giving up the following rights: the right to a jury trial, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights and enter a plea of guilty today? Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to enter a guilty plea today because you have decided that it is in your best interest to do so? Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
But it's my first time hearing about that. I never heard that before.
So if you go forward with what we call an offered or best interest plea, you're making very plain on the record that you are entering this plea only because you think it's in your best interest and that you're not admitting to the allegations, but it's still a conviction. So if someone is looking at your criminal history 10 years from now, it will show that you had one, I'm making it up, you had one in 2018, you had one in 2010, and you had a conviction in 2024. It's not going to appear in a different color because it was an offered plea. That's the point that Ms. Rutland was trying to make. Do you follow that? Okay.
Okay. And how do you plead to the charges of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon in indictment number 23 SC 189373? Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? And do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition? Okay, Your Honor, if this case had gone to trial, the state would have proven beyond a reasonable doubt that on April 29th, 2021, our victim, Leah Karg, brought her brother Larry O'Neill over to 1197 Joseph E. Boone, apartment 21 in Atlanta in Fulton County to visit one of his friends. Layla was advised that her brother went up to apartment 21 and she stayed in her vehicle. It was supposed to be a quick visit, but Layla said that it was taking too long, so she went up to the apartment and knocked on the door. She advised that a tall Black man wearing glasses answered the door and said, "I don't want all this stuff in front of my house." He didn't want all this trans shit in front of his house. Layla was advised that she walked away from the door and towards her car. When she got next to her car, the unknown male that answered the door came outside and started shooting at her. Layla advised that she did not know the male or why he would shoot at her. When the police officers arrived, the defendant had already left the scene. And when Detective Cooper later spoke to the victim and witnesses, they learned that the shooter's name was likely D'Angelo. Detective Cooper determined and confirmed that a Michael Angelo Reynolds lived in apartment 21 and was a convicted felon. A 6-photo lineup was shown to the brother, Larry O'Neill, and he was able to positively identify the defendant as the shooter. The victim was not able to identify anyone, but she only saw him for a brief time where she went into the door, whereas the brother was in the apartment with him. And the defendant is a convicted felon. And this all happened in Fulton County.
So was Mr. O'Neill, is that the name? Larry O'Neill?
The brother, yes.
Was he visiting Mr. Reynolds or someone else in apartment 21?
It's my understanding that he was visiting Mr. Reynolds.
So the victim's brother knew Mr. Reynolds or was conducting some business with Mr. Reynolds And when it was taking longer, that's when the victim knocked on the door and everything else ensued.
Yes.
Okay, thank you. Ms. Hardy, criminal history information, please, on Mr. Reynolds.
Hey, this defendant has 24 arrest cycles with arrests out of Georgia and Florida. Felony conviction in 2001 for aggravated assault. 2002 financial transaction card theft and forgery. 2006 burglary. There's a 2003 felony conviction out of Florida for grand theft of motor vehicle. 2 probation violations, nothing further to report.
Thank you, ma'am. Ms. Wood.
Judge, we do squabble with the facts, but we are entering into this plea because it's in Mr. Reynolds' best interest. I do believe he wants me to point out a couple of things to help the court better understand why we're in this position. The two gentlemen, or the two people that Ms. Rutland has mentioned and Mr. Reynolds are the only people that are even involved. There's no other outside witnesses. There's no surveillance footage, none of that. If this case proceeded to trial, we would be depending solely on Clark and O'Neill's testimony. Of great concern to Mr. Reynolds was the fact that the lineup I received yesterday, Clark is unable to identify. I was hoping to speak to Clark, however, this person is in custody in DeKalb County, and so that made it a little bit difficult. It would make for an interesting trial as well. Mr. Reynolds has been in custody since April 17th of this year. He was actually arrested in Miami. He was held there until he was extradited, so he's been here since June, I believe. I'll get that date in court. June 7th. He's eager to return to Miami to get to his mother who's sick. If the court sees fit, perhaps a suspended sentence or something that includes banishment might be appropriate here. The special conditions, I did want to just have some issues with that because since it is a best interest plea, it would be difficult for Mr. Reynolds to actually write an apology letter that the state is requesting. But yeah, otherwise, Judge, he's just ready to be done with this case and move on with his life.
Mr. Reynolds, how long had you been living down in Florida at the time you were arrested down there on 2021? But you were in Atlanta in 2021 as well.
Rented in Atlanta in 2021. I left 2021 of January.
Okay, but this happened in April of 21.
I left in January. When I got the park, they only had a photo of me saying that I lived there. I never was physically there.
Okay, I'm not trying to pin you down. I just want to understand the Georgia and Florida situation. So in April of 21, I know you were in Georgia. What you had an apartment that you were renting to other people or you were renting it?
It was my name on the apartment. I was renting it to some friends.
Got it. Okay, so if I looked at the list of occupants, in theory, it says Michael Reynolds.
There's only one person.
Got it. But you were subleasing it to someone else. So you had gone down to Florida at the beginning of 21 and were subletting your apartment. How long had you been in Georgia before you left?
Before I left, I wasn't here. I just left in 2021.
Right, before 2021, how long had you been in in Georgia?
Oh, I'm 23 years.
Okay, I got it. So were you originally from Florida?
Yes.
And then you moved to Georgia and were in Georgia for 23 years. And then in 2021, moved back to Florida,
Yes.
but still had an apartment here.
Yes.
Got it.
Because I had to take care of my mom.
That's my next question. You moved back to Florida so you could take care of your mom.
She
Okay.
went into surgery in January.
As in next month? Or she had January 2021 surgery?
January 2021 surgery.
Okay. And did that surgery go okay?
If the cancer comes and goes, it comes back. But she has no breast or anything.
So you hope to go back to Florida?
Sorry.
Do you have a place to stay?
I have to live with her because I lost everything being locked up in Fulton County.
Okay. She'll let you stay with her? Okay. All right. I need to ask. Sometimes mom's like, no, you're too much of a pain. You keep getting arrested. So she'll let you stay with her. All right. What are your connections still to Georgia? Do you have family here? Kids?
One,
How old?
25.
Okay, so an adult kid. Do you have family in Florida beyond your mother?
I have my uncle, I have my dad, I have some cousins.
Okay. Do you have siblings? Brothers or sisters?
I have one brother.
And is he in either Georgia or Florida? Florida. Okay. All right. Mr. O'Neill, that's someone you knew?
I've never known this. I don't know neither one of these people.
Okay. Any reason why he'd be going to your apartment?
I don't know, sir. I was in Miami. I didn't know nothing about, I didn't even know I had a felony a warrant for my arrest until I got arrested down there for trespassing.
Okay. What were you doing in Florida?
Hanging with my brother and them while they were selling drugs, and I got trespassing violation for that.
So maybe hanging with your brother's a bad plan.
I'm just being honest.
No, I appreciate you being, it's not making anything worse for, my goal would be for you not to get wrapped up in anything like this again. But if you're hanging out with your brother and he's selling drugs, you're gonna get wrapped up in stuff like this again. Okay. All right. Your mom's in Miami? Okay. Do you have any questions for me?
I don't know.
I wouldn't know what questions you have. That's why I'm asking.
Get home to my mom so I can take care of her. That's all. That's the only thing that's important.
Have you been able to stay in touch with her while you've been in jail?
I talked to my mom. The only thing I did is she's okay. That's not a good answer
Why don't you talk to your mom?
because I don't know her phone number by heart.
And your aunt doesn't connect the two of
My
you?
mom said she's been calling my mom, but my mom probably done did something with her phone somehow. You know, the cancer make her flip, or she flips on me sometimes.
Okay. You think it's all right though that you stay with her?
That's my mom.
Okay.
I don't care about her cussing me out or whatever. That's part of the cancer. I know it's not her.
Okay. All right. Well, Mr. Reynolds, I find that there is a factual basis for your plea, meaning if this were a trial, which it's not, and Mr. O'Neill came into court and said, here's what happened, points to you, and he identified you in the photo lineup, a jury could choose not to believe you that you were in Miami. I don't know what a jury would do, but it wouldn't be unreasonable for a jury to disbelieve you if Mr. O'Neill was a credible witness. In the same way, a jury could believe you, and maybe the trial will go well for you. But I very much understand why you're ready to put this case behind you and not run the risk of what would happen at trial. So I'll accept your plea. I find your plea is knowing and voluntary. Ms. Wood, can someone in my office sign the indictment for you?
Yes, please.
Ms. Rutland, can someone sign for you?
Yes.
Great. And Mr. Reynolds, we now electronically sign indictments, so we're not moving paper around. Is it okay if we put an electronic signature of yours on the indictment indicating your offered or best interest plea in this case?
What's my name?
Not if you say it's okay. If you say it's not okay, then we'll do this another day. It's all right? Great. Then we'll affix your signature as well. Do you have a weapons carry license issued in Georgia? Ms. Rutland, were you able to speak to Ms. Clark about how this case might resolve?
Yes, she left it to the discretion of our office and didn't have any opinion.
Okay, got it. So Mr. Reynolds, on count one, I am going to sentence you to 10 years to serve 6 months with the balance suspended. Count two will be 5 years consecutive to count one, balance suspended. And count three is 6 months to serve concurrent with count one. So that's a total sentence of 15 years to serve 6 months with the balance suspended. The special conditions of your suspension are, number one, that you stay out of the state of Georgia with the exception of the Lookout Mountain Judicial Circuit, which is way up by Tennessee. So if you need to be in Georgia, you can go be way up by Tennessee. Otherwise, don't be in Georgia while you have this sentence going. And number two, you shall obey the laws of Georgia and the 49 other states of the United States. It's not probation. It's not community service. It's basically go be with your mom and don't come back to Georgia.
Never in my life at all.
No, that's not what I said. It's for the duration of the sentence.
Just for How long, how many years?
It would be 14 and 1/2 years. Your son will need to visit you. But you're not on probation. You don't need to report to a probation officer. You don't have community service. It's you being in Florida, not being here, not being near that apartment. And if you've got family in Georgia, they can visit with you. They can come right down to Jacksonville. They don't need to go very far into Florida. You can come up from Miami. But you are committing to not being in Georgia. Other than that circuit, you guys could both go to those counties that are in that judicial circuit, but it's not the metro Atlanta area. Okay? Any questions about that?
But am I getting released?
Yes. I will sign your final disposition today, and they'll run the math about the 6 months, and you will be released after you've served the 6 months. Okay?
I've already been locked for 6 months.
Then you should be released in the next couple days. And if you're not, you reach out to Ms. Wooden and she'll let me know, and I'll ask the sheriff, why is Mr. Reynolds still there? Let's do the math. So you ought to be out, probably not today because it's about lunchtime, and they'll have to process all that. But tomorrow, if you're still in and it's Monday, reach out to Ms. Wood. Okay?
I don't know how to reach out to her.
We'll write my number down for you.
Great. She'll get you that number and you give her a call. All right. Ms. Rutland, anything else on behalf of the state?
Nothing further.
All right.
Thank you, Judge.
You bet.
Thank you.
Mr. Rao, I need to go, but I will be back. Why don't we try to reconvene at 1:30 and see what we're doing? Okay? Thanks.
That's not the one on this is all yet, so then it's all good too. I haven't given her specifics. And you see what? Yeah. He's got 2 cases, that one's
All right, I gotta go. But I'll swing back by 1:30, and we'll see what we're doing with Chalmers. Thank you, Ms. Wood.
Thank you, Judge. I've hit my max. I know.
Just send it to me.
But yeah, just send it over and I'll say.
Yes. What's left? Oh, okay.
Okay, yeah, I saw that case on the trial calendar for January 30th. So we have some time for that. Yes, we have to take it. Okay, yeah, we'll be fine. All right.
Thank you. I appreciate it. When are we gonna be back in our courtroom?
Probably Monday.
Oh, thank God.
I'm serious. I'm with you on that one.
I'm ready.
Now you look like to get into that one.
Oh, my gosh. Yeah, I've seen him so many times at the jail and he's like, yeah, I'm ready to do the plea. And then he gets here. So fun. Oh, yeah. And it was really bad. I don't know if you were with us the day. Do you remember?
When he came, that I remember.
Okay.
Oh, Lord.
Yeah, because after that, it's been like completely downhill since then.
He felt good out.
Lost it. I got it, okay.
So is that case pleading or do you know?
He might come out negotiated.
Okay.
I wish they forward.
So then if that's the case, there's only one case left. Oh, he's on bottom. Yeah. Oh, for sure. Oh my gosh, I need to rescue. I was. This closing argument. Cause I had been watching porn and I was like, okay, listen to you. No, it was like, I watched. Oh, yeah. That's why I was down in court. I was like, is this funny? Oh, I'm like in my Christmas mood. It's like a, yeah, it's like a fun color. Oh, we started talking about the cat. It was awful. I think so too, because I've been watching. Not gonna get like hardly any time. Less than a year before we bought it out. Oh, I didn't even need a offer. So now I got. Oh my God. Oh, that's awful. Right, right. Yeah. Right, right. Because that's what happened, they don't know how to verbalize this. Oh my God, guys. It's long. Oh my God. See, I did this good. Okay, I did get you statement. Why? 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 Yes, that's what it was. Yeah. I hate it. Oh, I can't stand it. I can't stand it. I just bought a shirt the other day that says, "Stop talking to the police," seriously.
That, yeah.
Oh my gosh.
Mm-hmm.
Oh,
Yeah.
I can't, yeah. Oh, will you be here tomorrow? You want to?
I'm gonna be on Zoom.
Good for you.
Because we're gonna drive next week. so-
I know, okay. Well, you have a good weekend.
You too. I forgot today's only Thursday.
I know.
It's moving to the left. Oh, this is a desktop one.
Yep.
Yeah, so no.
And we're doing those in the mornings before 9 o'clock.
Okay, perfect. And then we also, which ones are y'all doing today? We also are in one downstairs. But they're
Good afternoon, Judge McBurney's chambers. Just trying to see if it's been assigned. What's that? What's the case number?
Yeah, so I guess that's come back and ain't send nobody, right? You said it's 1:30.
Yes.
Let me go grab eat my food right quick. I'll be back. What, like 1:20, 1:40, 1:15?
Yeah, I'll probably go down to get them,
Okay,
and then have them ready when you come.
all right.
Everyone. Code ratings are enough, so 5B, 507. Oh, say both. Yeah, well, yeah, but he's come up. When they pull that, I know. I'm gonna do a piece of paper and they gon', you know what I'm saying, just have what direction. Then they can be able to say, well, hey, this caliber. Yeah. Okay,
That was cool, I'm not going there.
me too, when I got elevated, I went that way.
Well, yeah, I'm not used to coming in. You riding the car? It's me. I don't know why they feel like somebody owe them something. People that do all kinds of stuff. They don't owe me nothing.
They only 20 years old.
I wonder how they were. They don't really look old, but it's hard to tell since he.
So, where the sergeant done?
In my bag at the house. Well, now they keep saying, well, since you got your certificate, you official, but.
Oh, you talking about to the 20th?
And plus they haven't,
So they keep y'all here, they ain't.
that's right, that's what I was about to say, they haven't given us an assignment yet. I didn't know what they're gonna do. They said, he said we're supposed to.
Will be here next Thursday.
Somebody said something supposed to come out tomorrow. Make a list.
I said it would come out tomorrow.
Yeah.
Or Monday. And that'll be like effective immediately or effective Wednesday.
Right, on the 20th. But,
You stay on, you what?
You think so?
Put up.
Look, Richie she ain't gonna be happy, she don't want nobody to supervise her.
It's also about each other anyway.
But, I don't know, they said it was come out like first, but I didn't hear that. But yeah, I did hear they said maybe some demotions and,
Promotion?
tomorrow, everybody heard, you know.
From y'all guys?
No, I guess it's not.
Oh, it's about 8.
I heard them.
What?
Let's see.
How they can do that?
You can read them on Chris.
I heard, yeah, she was asleep. I don't know what's up.
So, yeah.
I know they did on Johnson.
Who's Johnson?
Lieutenant Johnson. Lieutenant Johnson.
Okay.
He job, they said he was lost.
They
Yeah, see?
so that way, they stuck him up my operator.
Oh, Derek Chill. You see the pictures? See the pictures?
I just saw him, I didn't see that close, I just saw the news. They showed it
Oh,
down.
this what I'm doing?
He showed it down attack.
It did, I didn't see that.
I think they showed it like yesterday.
I heard they turned themselves in.
Somebody else gonna turn in and be different. Yeah, they was. He kind of done, straight, it's not gonna look, manage to.
So what trying to show them? Yeah. No, no. Hey, sorry, I missed your calls. It was a joke for us. Working on it, so we're actually. What are you doing? So something. You wanna like mess up live, no? Oh, yeah. Yeah. Oh, the left, no. You figure things out. Come on, baby. Okay, how about that? On the side. I see it. You get it, very. Go ahead, like right now. Right now. This is what you can. With that, but still. Why that kind of idea, I don't know who you hear. I'm sure you. Yeah. Yes. Yeah, they're responsible. That one out and then we. Well, I say, they're gonna be. Oh, yeah. You saw. But they didn't, you know. You got to see the it ain't like there's no. About seeing. But I didn't have. I didn't do that. And then one day. Yeah, come on. And you know, 7 hours, no, I need you.
Mr. Partridge, how are you?
I'm doing well, Judge.
What's the latest involving Mr. Chalmers?
I spoke with his mother and aunt, and they're relaying a message to the grandmother.
Wow, that's all the ladies on his side.
Yeah, so Mr. Chalmers' father was also a dwarf, and they lost him to medical complications early on. So he's had these three women in his life, just kind of as advisors.
Sure.
So they would like at least the opportunity to talk to him or at least know where he's standing. So I just want to check with him right now.
Okay.
We may be asking the court and the state for at least 24 hours to finalize a decision
Okay.
as it relates to plea or not. I know that the state has some more work to do, and so would I guess, if depending on which way we go. So if he's gonna plea, I'm asking him to let me know by tomorrow
Okay.
at the very latest.
Okay. I'm here tomorrow, so we can always make that work. We also could just get confirmation that it's a plea, and that's what we do Monday morning. What I don't want to do is leave it hanging. So Mr. Rao's like, do I get ready over the weekend or not get ready? I've been told by the state they're ready to go on Monday if it's pick a jury. And I know you've been ready. We have the wild card of Clayton County, and we'll need to work through that. And ideally, we'll get a better sense of that. Assuming Mr. Chalmers doesn't say, yeah, let's work it out tomorrow, meaning Friday, we'll want to get a better sense of what Clayton is looking like again. So Mr. Rao's not spending the weekend getting ready or making someone else get ready for him. If you're going to be stuck going out in front of Judge Malone. But why don't you talk with him for a little bit? I'll just do something right here, and then we'll still get him on the record saying I want 24 hours or I've already made up my mind. But chat with him and then let us know.
Yes, sir. Thank you, Judge.
Uh-huh. How are things back there? Is it nicer or is it different, laid out differently from, it seems like there's some hallway, it seems different.
It's four tanks on this floor than it is on our floor.
Yeah.
Yeah. It's, it's longer as well. Yeah. So you haven't been back on?
I probably did when I started. I just don't remember. That was a long time ago. It's blue. I noticed that when that door opens, it's all blue. And there's just this hallway down there. I remember on our floor, I thought it sort of just goes straight in.
On our floor, it's similar to this. You got the wall, make it left and then go to the other courtroom.
Okay.
Yeah. But down here is.
Well, I can't see from this angle. Is there also a straight ahead? Like if you open this door, can you walk straight? It looks like there's a wall in the way.
Those are holding tanks. And you go right, it's elevated and it's two more holding tanks.
But on our floor, there's like it just seems like if you go in, if you were to turn, there's a wall right there. Cause usually people.
Yeah, the wall is right back farther down.
Okay.
So it's similar.
Okay.
He's in the same position, Your Honor. He wants to talk to family. There's also potential information regarding his co-defendant that he wants to potentially solidify with family as well, as far as the whereabouts of the co-defendant. I don't want to put that on record, but nonetheless, we might be able to negotiate something a little different if we're able to pinpoint the co-defendant. At least my conversations with Mr. Abadi.
That person's indicted, just a fugitive, or it is a Fanu-Lanu situation?
Indicted fugitive,
Okay,
is my understanding of it.
I think that's right. I remember there being,
I remember looking at the indictment.
I'll look it up while we're waiting, but let's bring Mr. Chalmers out. We won't touch upon that second part of it. But let's just make sure we get on the record where we are and what the timing is. How would you know that, well, I'll ask that with him out here. All right, let's get back on the record in Mr. Chalmers's case. We took a break for an hour plus. And as I understand it, Mr. Chalmers, during the break, Mr. Partridge, one, was able to speak with some of your family members, and then two, relayed to you some of what they were thinking. And then 3, most important, you have told Mr. Partridge you would like an opportunity to speak with those family members, which I think means going back to the jail and using the phone system there. Is that correct? Okay. Time is running short. I'm happy to give you that opportunity. If I look at tomorrow's schedule, I am stuck in a long motion in the morning, but in the afternoon, I've got a plea and arraignment calendar, which is pretty open. So maybe what we want to do as a default is have you brought over tomorrow. We know you're coming over. That way you two can touch base. And why don't you plan, Mr. Partridge, on being here at the 1:30 calendar? And that way, Mr. Chalmers will be here before then. So if you want to show up before then and he's up, and we're in this courtroom tomorrow. So we'll be back here in 5D. Next week, we should be home. You guys can talk in advance, but at 1:30, I'll be looking to get an update from you and Mr. Rao, whether it's you or Mr. Hawkins, if someone from the DA's office, and you can zoom in, that's fine too. But if you get wind from Mr. Partridge that it's going to be a plea, then probably having one of you in person would be good. I don't know what your schedule's like.
I think that should be fine. I have to be in 4D in the morning, so I don't know how long that.
Okay, you may feel liberated when you get here, but
Perhaps
if you are so liberated.
The only thing I would ask the court is, so there is a witness that lives in South Georgia that Mr. Hawkins and Mr. Brown are going down to drive to go see. The only thing I would ask is if the court would consider, if it looks like, I don't want to put words in anyone's mouth, it seems like we're leaning towards a potential resolution short of trial. Given that they have to utilize resources to go down there, if the court wouldn't mind potentially moving this case from the next week's calendar, given, I guess, the position that the sexual assault unit finds itself in, ready for trial. If we could just move that so that way I can tell Mr. Hawkins they don't have to go down to South Georgia to go interview this witness in preparation for a trial that may not in fact take place next week. I would just make that request to the court.
Okay, I hear you. This is the case we'll try if it's not a plea. And the other gentleman is on bond, the rape trial we've got. So it would be the backup to this one. Now, a plea would make this not a trial, or if we learn definitively that Mr. Partridge is going to trial on Monday in Clayton County on an older case, and it sounds like the case is older. I don't know how definitive it being a trial is, and I haven't engaged with Judge Malone at all. That would be another thing, but that we might not know before Mr. Hawkins and is it Mr. Brown?
Yes.
Mr. Brown would need to decide, are they driving to South Georgia? My counsel would be keep on getting ready. And then maybe you and Mr. Partridge can have an offline conversation that he can handicap it, like it's 90% is working out, and then you guys gamble about not going to South Georgia. But I am going to keep this in my mind as first out on Monday. And the only two ways right now, as I see it coming off, would obviously be a plea, and it's not a trial, or we learn that we've lost Mr. Partridge because of the older case. All right, so Mr. Chalmers, the way we left it before the lunch break was that, how long is this offer open? Is it through when we meet at 1:30 tomorrow, or what? Because we don't need to spin our wheels if the offer expires when Mr. Chalmers leaves here today.
I think it would be our preference to take the plea tomorrow.
Okay.
If we're able to do it.
All right, and that plea would encompass a non-negotiated plea?
Yes.
Okay, so Mr. Chalmers, I think things are unchanged from when you and I last spoke. The state right now is going to be recommending 20 years to serve. Mr. Partridge shared with me that there may be something that would change that would make the state interested in recommending less. And you and Mr. Partridge have been talking about that. That's on you and not on anyone else. But for now, I understand it. The state's recommendation will be 20. And Mr. Partridge will be arguing on your behalf for a time served. Leaves a lot of space in between. And the state's leaving that opportunity open through our reconnecting at 1:30 tomorrow in this same space. Between now and then, you need to figure out how to talk to the folks you want to talk to and think through with Mr. Partridge whether you're going to take steps that might cause the state to say, well, given this other situation, we're recommending less. They're not obligated to do that, and you're obviously not obligated to do anything to sweeten the pot for them, but that could be out there, and we'll see where that plays out. And the final reminder, I'm not bound by any of it. I don't get to reduce charges. So if the state reduces murder to voluntary, that creates a ceiling of that 20 years. So I can't go above that. But just because Mr. Partridge is trying to tug me down to time served doesn't mean that I have to or that I will, but I could. And certainly it's the only chance you've got of arguing for something less than life would be through this format. If you're found not guilty at trial, you don't have to argue for anything. But if you are found guilty at trial, we sort of have this reverse situation. By reducing the charges, the state can't go higher than 20. And so they're basically saying, we think 20. If we flip it around and you're found guilty at trial, the floor is life. And so Mr. Partridge could very eloquently share with me the reasons why you being out to be able to get medical care and be with family make a ton of sense. But the legislature has put that floor of life, and I couldn't go below it even if I thought there was a real compelling argument. Do you feel like you understand your options right now?
I don't understand. I didn't want to see the plea come in the probation.
Say that last part. Does the plea come with probation?
Yeah, like you said, 20 years to serve, like 20 on paper. I mean, I'm saying like.
Got it. Good. I think I understand your question. The state's recommendation, as I understand it, is 20 years to serve. Now, those are parolable. I'm not aware of there being a recidivist notice filed. And so what the state would be recommending is 20 years in custody, but that's a parolable 20. And Mr. Partridge can talk to you about what the math would look like. It would not be 20 to the door. It would be less than that because you would be parole, unless you, while you're in prison, do stupid things. You would definitely be parolable, but they're not talking probation. Now, I'm free to do whatever. I could give you 1 year probation for voluntary manslaughter. I don't want to get your hopes up. I don't see that being a realistic sentence, but voluntary manslaughter is 1 to 20, and it can be probated, suspended, or it can be served. And the state is recommending to me 20 to serve. And so if you get out before 20, it's parole. That's not me. That's not the state. That's parole sorting that out. What I heard Mr. Partridge previewing, and I appreciate the preview, is that he'll be arguing for time served. I might give you some probation, so it's not just you get out and there's no sentence. But if I were to go along with Mr. Partridge's sentence, and I'm not saying I am, I don't want you to leave here thinking, hey, the judge is down with that. But just making numbers up, I might do 8 serve 3, reduced to time. I don't know how long you've been in, but 8 serve 3, reduce the 3 to time served, balance probated. So you might have 5 years probation. I don't see a case where someone was shot and killed saying, you're done, you go home. I would likely put probation in there if I'm gonna go with something less than what the state says. Okay? Did that answer your question? Anything else? You feel like you understand what I don't want to have happen is that you come back here 1:30 tomorrow and like, I don't know what we're talking about. You know what we're talking about. Okay? You talk with family, you talk with Mr. Partridge, and we will see you and Mr. Partridge and someone from the DA's office at 1:30 tomorrow. And it'll be real quick. I'm just gonna be saying, we're doing a plea or not? Not like, well, I need to think about more or less. You will have already thought about it. And you'll say it's a plea and we know the parameters. It fit just this 20 unless something changes the state's mind and they come down a little bit. And then I know what Mr. but then we'll have that conversation. Mr. Rao, you had mentioned that the family of the deceased wants to be heard, which they will be and they're entitled to be. If you get word from Mr. Partridge that it is a plea tomorrow at 1:30, would we be able to make that happen, even if the family's zooming in? Or would we be taking the plea as in Mr. Chalmers enters the guilty plea and I accept it, but we defer sentencing for a week so that family can be here in person.
Ideally, it would be the first option, but I'm just thinking the way things have progressed with our conversations with them, no problem, be the latter.
Okay.
That's possible.
It is, no, I want to accommodate them, especially given you sharing with me that they're going to come in unhappy with something less than life. And they're entitled to be unhappy and they don't dictate what you do. You look at all of the variables in a complicated case. But if you conclude or the victim advocate concludes that it is better for them to be heard in person, then we'll just break it into two pieces. We'll lock in the guilty plea, so Mr. Chalmers knows I'm not going to trial, but I also have locked in this commitment from the state that the ceiling is right here. Okay. All right, we'll see what happens at 1:30 tomorrow, same place. Thank you, everyone. I'm assuming you can be here. I was sort of acting like Partridge would beam in.
I'll be here early to have a conversation prior to 1:30.
Okay.
But yeah, absolutely, we'll be here.
Sounds good.
Yes, sir.
Thank you, everyone.
Thank you. And I'll email the court the information for the Malone case, just in case as well.
Good, please do.
Yes, sir, will do. Thank you, Honor. That concludes my happy.
You may, and Mr. Rye, you may as well. I think that covers it for today. Let me see what else we've got. Nothing in this courtroom, so I can shut down the Zoom. Thank you, everyone.
Yes, sir. Thank you, Judge.
Judge, do you have a Takai key potentially if you know coming to court tomorrow or in court tomorrow, defendant?
I know exactly who that is, and I will look on tomorrow's calendar.
Yes, we do.
We do, okay. Good thing I hadn't closed out the Zoom. Is that now yours?
No, I'm all over the place in the office, so
Yeah.
one of my responsibilities is supervise 5 courtrooms, this being one of them.
All right.
And it's my understanding that, I was trying to see if that case was on the calendar tomorrow. I couldn't see.
So it's plural? He has cases?
He has at least one more open indicted case for a case that he picked up while out on bond for,
And I think that's the main reason why the case is really on the calendar is because he has some co-defendants that are being arraigned.
Yeah, so he and one other guy, blanking on the last name, had a case together with me. Mr. Muse? Yeah, they had a case. The weird thing with Mr. Key is he had no bond. It was a direct indictment and he never had a bond. And I was working with his lawyer. Hey, you need to get a bond. This isn't working. And then he picked up a case with a big old gun and he now has no bond and won't be getting. I told his lawyer that, but I think he may have a third case now too. And one of the cases is like 5 defendants, one of whom is Muse. So it was Key and Muse and they're like this bad Velcro ball and are bringing more cases here, but any more cases he brings would be because of something that happens in the jail, because that's where he is. And so I will see him tomorrow. But Muse, the other little piece, Muse, who was also out on bond, got shot literally like 15, 16 times, survived, but now is also in custody for having, while on bond, picked up new charges.
is that an afternoon calendar or a morning calendar?
It's afternoon. It's 1:30. So when we're dealing with Partridge, it's Key and Muse and their associates.
Trying to avoid this office, but I guess that won't be.
Super. Okay. That'll be good for all of us.
Thank you, Judge.
Yep.
The 1 o'clock is council drill.
Yes. Tank. Ms. Nix withdrew the motion. So we're done. Mm-hmm.